A very warm welcome to you. Today is a very important day as the Supreme Court is set to deliver its verdict in the case challenging the Union government's 2019 decision to repeal the special status of Jammu and Kashmir under Article 370 of the Constitution. The Constitution Bench, led by Chief Justice of India D.Y. Chandrachud, had reserved the judgment on September 5th, 2023 after an extensive 16-day hearing. The petitioners in the matter had challenged not only the abrogation of Article 370 but also the J&K Reorganization Act, which resulted in the bifurcation of the state into union territories of J&K and Ladakh. Heightened security in the valley is in place regarding the decision on Article 370 and 35A. VIP movements are restricted, including on the national highway. Cyber Police has issued a social media warning, closely monitoring online activities. In Srinagar district, deputy magistrates received special instructions for every area, with officers posted to maintain law and order. Now, let's take a look at the key arguments presented during the hearing. Let me go to the wall and let me take you there. Now, what are the issues at hand? And we will stay on them a minute each. Article 370 is not permanent. This is Government of India's argument in the Supreme Court. It says Article 370 not permanent, not a lasting privilege, impacts equal treatment. That is number one, a very important argument by the Government of India. Now it says it is a temporary provision labelled as such with an inbuilt self-destructing mechanism, which means that Article 370 was not envisaged as a permanent feature in the Indian Constitution. Full statehood commitment. Government plans to grant Jammu Kashmir full statehood. So basically the argument is that the statehood will be given to the state of Jammu and Kashmir, which is now a union territory. Psychological duality, again a very important argument. Abrogation eliminates psychological duality for the residents. Internal autonomy not to be mistaken for just sovereignty. Government also says, and another very important argument, peace post abrogation, tourism, administration, social reform, right to education, property issues concerning women. They were all important. Can we go back to the previous one? Can we go back to the previous? So fundamental rights denial. Article 370 hindered fundamental rights, as I said, right to education. We will go back to these again, the government's argument. Let's move on to the other one. Not a lasting privilege, impacts equal treatment. Now this is the most important thing. Not a lasting provision. Labeled as such with an inbuilt self-destructing mechanism. Labeled as such with a self-destructing mechanism, government plans to grant J&K full statehood. That's the full statehood commitment. Abrogation eliminates psychological duality for the resident. These are the arguments of the Government of India. Very powerfully argued. Very powerfully argued. On this issue, I am joined by my input editor, Brajesh Pandey, legal editor, Ashok Bagria. I will also be joined by Aditya Rajkaul. I will be joined by lawyers. But before that, on the government's argument, let's stay with these graphics. Ashok, can you give me sum and total of what government was saying in the court?
Well, Karthikeya, let me put it very briefly. That number one, the Government of India is saying that Article 370, which granted special status to the state of Jammu and Kashmir, was not a permanent arrangement. If you read Article 370, it says it's a temporary provision, and the Government of India was within its power to revoke it, number one. Number two, there was this security argument by the Government of India. The Government of India, led by the Solicitor General of India, Tushar Mehta, very strongly put forward before the Supreme Court that please try to understand, ever since August 6, 2019, there has not been a single incident of stone pelting in the valley. This area has been disturbed. There have been numerous instances of law and order situation in the state, but after August 6, 2019, not a single incident has happened.
Okay. Why was this furor? I understand that, opposition was taken by surprise, understandable, when Home Minister started reading the provision. But Ek Nishan, Ek Samvidhan was something which was deeply, innately associated with the politics of Jansangh and RSS. It was part of their electoral campaign even in 1950s. So when this came about, why were people surprised? Because it was also part of BJP's manifesto.
It was part of the BJP manifesto. People were surprised because nobody was actually looking forward that the government could actually go ahead and do it.
Okay.
Because it was there, but nobody thought that the government could actually implement it. The government implemented it, and that is the reason they took everybody by surprise. That by abrogating Article 370, they said that that J&K and Ladakh becomes union territory. The point is that what is happening is, Karthikeya, as Ashok said about the government side, what the opposition and the others, petitioners are saying is that, the Article 370 was said to be temporary, but a decision on it was supposed to be taken in the Constituent Assembly between 52 and 57. And they say that since no decision was taken, one way or another, yes or no, it became permanent. So that is the moot point of what the entire gig is going on, and it will be very, very fascinating to see how the Constitution Bench of India treats it. Will it go with the petitioner's argument, or will it stay put with the arguments put by the centre?
Well, one thing I just want to tell you an interesting thing about these 5 judges who are hearing this matter. Now, this is a 5-judge combination. It's a Constitution Bench led by the Chief Justice of India. Now, besides the Chief Justice of India, the 4 other judges on the bench are the senior most judges of the Supreme Court of India, and besides, except for Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice B.R. Gawai, Justice Surya Kant, all 3 of them will go on to become the Chief Justices of India. So technically, on this bench, we have 4 Chief Justices of India. One is a presiding one, and 3 future Chief Justices of India. So the composition of the bench was also very, very cleverly designed by the Chief Justice of India, in the sense that it's a very important matter, and let it be adjudicated by the 5 senior most judges of the Supreme Court.
Okay, now let me take you through what the petitioners said, the other side of the story. So these are the arguments by the government of India. Now these are the petitioners' argument. So that's the petitions. You had the government of India answering, you had the petitioners there. So the petitioner constitutional requirement, state government's concurrence needed for Article 370 revocation. They are basically saying that when there is, how can Parliament of India subsume the responsibility of the Constituent Assembly? They are saying that the state government's concurrence needed for Article 370 revocation, because their argument was that it resided in the State Assembly, the idea of sovereignty. No elected governor's assent is an expression of people's will. Basically, they are saying, since there was no government in place, there was a president rule, governor cannot subsume the will of the people. So the logic is, will of the people
and
is...
Usually it is said, Karthikeya, that the governor can act only on the aid and advice of the Council of Ministers,
Absolutely.
which was absent here.
Okay, absolutely. So they are saying that how can a governor subsume the will of the people? The assembly had to be in motion. That is the argument of the petitioners in the court. Let me be very clear. I am giving you the argument of the petitioners. First, I gave you the argument of the government of India. State legislature approval needed to split state into union territories. Basically, there is a rule. India is a deeply, it's a federal country, and federal structure is part of the basic structure of the constitution.
Well, I just want to say one thing.
We stay on this. Please don't move this. We stay on this. Yes.
Yeah. This particular argument will have far-reaching implications for the federal structure of the country. And now, I'll tell you why.
I just need to stop you. I just need to tell people that whenever states are formed, for example, Telangana was formed, Chhattisgarh was formed, Uttarakhand was formed, Uttar Pradesh legislature passed a resolution creating Uttarakhand. Madhya Pradesh legislature passed a resolution creating Chhattisgarh. Bihar legislature passed a resolution creating Jharkhand. Now, in this case, the argument of the petitioner is state legislature approval needed to split the state into union territories. Yes, Ashok.
So the point here is that in the past we have had situations where states have been split into a state and a union territory, and for doing so, the will of the state legislature has to be taken into account. So for instance, you gave the example of Uttarakhand and Uttar Pradesh. It was a resolution which was passed by the Uttar Pradesh Legislative Assembly, and then it happened. Now here we are dealing with a peculiar situation which has happened for the first time in the country, where a state has been pulled down to the status of a union territory, and this has never happened in the last 75 years. The second thing here is that you cannot reduce the status of Jammu and Kashmir from full statehood to that of a union territory without taking into consideration the opinion of the state legislature. Now that's a very important thing, because tomorrow what the government of India can do unilaterally is that it can pass a presidential order and can reduce any state to a union territory status.
There are a couple of bites we have. Let me play out the bites. What people are saying, what politicians are saying, what former Chief Minister of Jammu and Kashmir saying, Mehbooba Mufti or Omar Abdullah. Let's have a quick listen to the people who are important to the politics of the state, and those who are important but are not in the politics of the state but have a say when it comes to J&K.
वर्डिक्ट आएगा तो उस वक्त पता चलेगा कि क्या है, कि कश्मीरियों के हक में है, जम्मू कश्मीर के अवाम के हक में है या उनके खिलाफ है। इस वक्त हम यही कह सकते हैं कि हम 2 महीने या 4 महीने से इंतज़ार नहीं कर रहे हैं। हम गुज़िश्ता 4 साल से ज़्यादा अरसे से इस दिन का इंतज़ार कर रहे थे कि कब सुप्रीम कोर्ट, क्योंकि पहले 3 साल में तो कोई सुनाई हुई नहीं, सिर्फ एक दफ़ा आधे घंटे की सुनवाई हुई थी, और जिसका हमने भी, मैंने खुद भी और मेरे साथियों ने अपनी पब्लिक मीटिंगों में पिछले 1-1.5 साल से कहा कि जब तक सुप्रीम कोर्ट इसको डे टू डे हियरिंग नहीं करेगी तो तब तक फैसला आना 50 साल में भी नामुमकिन है। मैं मशकूर हूँ सुप्रीम कोर्ट का कि उन्होंने ऑलमोस्ट कभी कभी डेली बेसिस पे इसकी सुनवाई शुरू की। सब लोगों ने, सरकार ने, दूसरे लोगों ने, इंडिपेंडेंट लोगों ने, जो किसी पार्टी से भी ताल्लुक़ नहीं रखते थे, उन्होंने भी अपनी याचिकाएं, अपनी एप्लीकेशन सुप्रीम कोर्ट की तरफ रुजू किया, और सुप्रीम कोर्ट ने जब से सुनवाई की तब से उन्होंने ज़्यादा समय नहीं लगाया। उनका आभार प्रकट करता हूँ, उनका शुक्रिया अदा करता हूँ। लेकिन इस तवक्को के साथ कि जो सरकार ने गैर कानूनी फैसला लिया था, क्योंकि ये पावर्स असेंबली की इलेक्टेड गवर्नर के पास थी, नॉमिनेटेड गवर्नर के पास नहीं थी, स्टेट को भंग करना और रिकमेंड करना, तो उस तरीके से ये अनकॉन्स्टिट्यूशनल है, और बहुत भी कई चीज़ें हैं जिसकी वजह से अनकॉन्स्टिट्यूशनल। तो कॉन्स्टिट्यूशनल,
जब हम सुप्रीम कोर्ट में गए थे 2019 में, तो इंसाफ हासिल करने की उम्मीद लेके गए थे। आज भी हमारे जज्बात वही हैं। हमें बेसब्री से इस दिन का इंतजार था। कल सुबह ऑनरेबल चीफ जस्टिस और उनके साथ 4 ऑनरेबल जजेस जो हैं वो अपना फैसला सुनाएंगे, और हम इंसाफ की उम्मीद लिए बैठे हैं। मैं अगर मगर में नहीं जाता हूं ना, जिस तरह आप कहते हो अगर फैसला आपके हक में नहीं गया, मैं उसी तरह कहूंगा ना अगर फैसला हमारे हक में गया। दोनों चीजें मुमकिन है। फैसला आने दीजिए, उसके बाद हम बात करेंगे ना। आज कोई ये नहीं कह सकता है कि उनको पता है कि ऑनरेबल जजेस की तरफ से क्या फैसला आने वाला है।
देखिए, सुप्रीम कोर्ट ने पहले ही कई बार इस मुद्दे को सुनने में बहुत देर कर दी। 5 साल लगाए इस मुद्दे को सुनने में। उसके बाद मैं समझती हूँ कि खुद सुप्रीम कोर्ट ने कई बार जो पुराने हमारे जजमेंट्स आई है उसमें ये कहा गया है कि 370 को जम्मू कश्मीर की कॉन्स्टिट्यूएंट असेंबली के बगैर कोई नहीं हटा सकता है। तो मुझे लगता है ये फैसला तो सीधा होना चाहिए कि ये जो उन्होंने किया 2019 5 अगस्त को वो नाजायज था, वो कॉन्स्टिट्यूशन के खिलाफ था। जम्मू कश्मीर के खिलाफ था, जो जम्मू कश्मीर के साथ वादे किए गए 1947 में, उन वादों के खिलाफ है। जो मैं पिछले कल रात से देख रही हूँ, जिस तरह से अलग अलग जमातों के, खासकर पीडीपी का मैं सुन रही हूँ, हमारे वर्कर्स के लिस्ट लिए जा रहे हैं पुलिस थानों के जरिए। लगता है कि कोई ऐसा फैसला आने वाला है जो जम्मू कश्मीर या इस मुल्क के हक में नहीं है, बल्कि सिर्फ बीजेपी के एजेंडे को आगे चलाने के लिए है। इसलिए कुछ प्रिकॉशनरी मेजर्स लिए जा रहे हैं, जिसका मुझे बड़ा अफसोस है। मगर फिर भी मैं सुप्रीम कोर्ट को ये बताना चाहती हूँ कि आपकी जिम्मेवारी बीजेपी के एजेंडे को आगे चलाने की नहीं है, बल्कि इस मुल्क की सालमियत, इस कॉन्स्टिट्यूशन की सालमियत की है, उसका लिहाज कीजिए।
So a lot of different takes on Article 370 by three former chief ministers, in fact I would say. One from Congress, one from PDP, one from National Conference. And now he's not even Congress, he's former Congress because he has his own Congress, which is Azad's party. Now reorganization, the legality, violation of federalism principle. The petitioner argument is that the abrogation goes against the basic structure of the constitution. Now basic structure of the constitution as an element is part of our history in 1970s. It got introduced that the government of the day, executive, cannot tinker with the basic structure of the constitution. There are provisions within the constitution where you park special amendments, special provisions, which cannot be intervened, tinkered, changed, stopped or prevented by judiciary. What is that schedule called?
Well, that's not a schedule. That was the judgment in the Keshwan and Bharti case, where the Supreme Court of India evolved the concept of the basic structure. Now in the basic structure judgment, the Supreme Court of India said that there are some features of the constitution which are untouchables. You cannot touch it, neither the legislature nor the executive.
Okay.
Nobody can touch it.
Correct.
Because the constitution, when it was drafted, it made an edifice which has to be protected.
Now, I wish, I can take out that bite because Mr. Gogoi, Mr. Gogoi, who was Chief Justice of India, now a Rajya Sabha member, actually said that the basic structure of the constitution is not a
sacrosanct.
It's
not inviolable.
It's not a sacrosanct. And he said this in Rajya Sabha. And, it created a sort of a silent furor within a lot of establishments, because the basic structure of the constitution is like an agreed principle. And a former CGI says that it's not something like sacred, which cannot be tinkered, or, people can't think about changing it. And he said this on the floor of the House, and when you say things on the floor of the House, there is no judicial scrutiny. But abrogation goes against the basic structure. Constitution recognizes special condition and needs, asymmetric federalism. Now this is a very important word, asymmetric federalism. A lot of people think that federalism, it starts and ends with Kashmir. No, it doesn't. It's not like that. You have, if there's an Article 370, you have Article 371A, Article 371B, Article 371C, Article 371D, Article 371E. Bottom line is, northeastern states like Mizoram, Nagaland, Arunachal Pradesh, even parts of Himachal are protected. For example, you can't buy land, or you can buy a
only
particular,
up to a point.
Quota of land, but then you can't add on to that patch of land. That is part of Uttarakhand. In Himachal Pradesh, outsiders cannot buy land. You have to be an industrialist, horticulturalist, some sort of a business to the local people. In Arunachal Pradesh, you have an inner line permit. In northeastern states, if you want to go there, first you have to go to the Bhavan, get an inner line permit from here, then go there. When I was traveling from Assam to Itanagar, Brijesh was there with us, 3 separate cars we were going. We had to get down from a car. It was like a small border. There was a checkpoint. We all got accounted for. And then when we went to Itanagar, that is called asymmetric federalism. Just simplifying it. Instrument of accession. Proof of an agreement between two independent states. Now, this is the most contentious part, because you see, there is a difference of a word. There are 2 words. Most of the states merged with Union of India. Junagadh merged with the Union of India. After Operation Polo, Hyderabad merged with the Union of India. This was the state And Karan Singh's father was the king. It was an accession. They acceded. So the argument is saying that it's a proof of an agreement, not transfer of a come. Yes.
I'll just come in. Kartikeya, here a very interesting argument was made by senior advocate Mr. Zafar Shah, who was representing the Bar Council of Jammu and Kashmir. And he said that if you look at the instrument of accession, it was a princely state. The instrument of accession said that, look, we agree to be a part of India. So it was akin to a situation where two people came together. There was shaking of hands, but there was no embracing. So in a sense, he tried to put forward an argument before the Supreme Court of India that there was a limited accession, and it was agreed that barring certain topics, the Parliament had no jurisdiction to legislate on those issues. So that is what was meant, that instrument of accession whereby the King of Jammu and Kashmir agreed to accede with India. He did so on limited conditions. There were conditions applied, as we have situations that conditions apply, and that is how it happened.
Okay, wonderful. The proof of an agreement between two independent states. After that, another graphic. Let's take another graphic. Instrument of accession, proof of an agreement between two independent states. Now, pre-abrogation and post-abrogation. This is very important. Special powers exercised by Jammu and Kashmir. No special powers exercised anymore. Dual citizenship, separate flag for J&K, single citizenship, tricolor, now the only flag. Now, just stay here, please don't change it. Just don't change it. You know, J&K after 1950s had a long history. There is something called Sheikh Abdullah Indira Gandhi Accord. तो जब ये अकॉर्ड हुआ था तो लोग मजाक में एक चीज बोलते थे, और वो ये बोलते थे कि इंदिरा जी ने केवल झंडा और निशान छोड़ दिया, बाकी सारी पावर्स ले ली हैं. So at that point of time it was successful. People outside Kashmir said this is the best level of integration. But then one also has to understand the public sentiment, the public mood. So in democracy, the structure of power, political authority is dynamic, and the change is reflected through will of the people. And I will be making this point again and again, that the public sentiment is important here. Let's move on. Article 360, financial emergency not applicable. Article 360 will be applicable. Pre-abrogation, no reservation for minorities. Minorities eligible for 16% reservation. So 370 also created problems. The progressive laws were not applicable in J&K. There were a lot of issues which could not be resolved, and they could not be resolved because there were certain barriers. Let's move on. Indians from other states could not buy land. People from other states can now buy land. RTI not applicable, something which UPA touted as like the amendment. RTI will be applicable. Very important. Duration of Legislative Assembly for 6 years. Assembly tenure of 5 years in J&K reconciles with every assembly in this country. Then loss of citizenship if a woman married out of state. This is something very important. You have to look at from the feminist point of view, from a gender point of view, from a point of view that it disempowers a woman. Woman retains citizenship irrespective of marriage. Irrespective of marriage, she retains her citizenship. Panchayat did not have any rights. Any rights. Panchayats will get same rights as other states, and it is very important because Panchayati Raj by any prime minister, whether BJP, Congress or any other ideological formation, says Panchayati Raj is the kernel of Indian democracy. In fact, Mahatma Gandhi spoke about it more than before any prime minister of this country did. He said that democracy lives in our villages. And what are villages about? They are about panchayats. Right to education not applicable. Children in the state will benefit from RTE. Now, before I play out a tic-tac of my colleague on this issue, I am also joined by Aditya Raj Kaul. Aditya, how do we put this debate in perspective? Because today a very important landmark decision is going to be given, whether it's going to be admitted or not admitted. But Article 370 cannot or should not be seen only from the perspective of uniformity of law. I think it should also be seen that its abrogation led to empowerment.
That's precisely correct. I think two legalities is what the Supreme Court of India Constitutional Bench will go into. One is whether this was temporary or in nature or not, and the way it was adopted at that particular time. And secondly, the way it was nullified. Was that the constitutional way? Was that the parliamentary proceedings that really happened because the assembly was not in function at that particular time? There was president's rule, governor was in place. So whether or not, so only these two legalities is mostly that the Supreme Court will delve into. That's what I believe. But you are precisely correct that there's been a lot of changes that have happened over the last 4 years. We've seen a lot of central laws that were not applicable, particularly with regard to equality to women, to the backward people, particularly the OBCs, the Valmiki community. In fact, I would give you an example of how the Supreme Court was shocked initially.
I can just stop you for a minute.
Sure.
Lawyer Sanjay Chadda is with us. I think he will be. He needs to go to the court. Your opening comments on this issue, sir. Thank you so much for joining me today morning. Before such an important hearing. Your opening comments. How is this a very important, a sort of a landmark judgment which the entire nation is expecting?
Look, there are various legal aspects which most of them, I was watching it from the beginning. You have taken those important topics while discussing in the matter when in your debate. What I feel, it is certainly going to be a landmark judgment if we talk about what is the role of the Constituent Assembly, whether Parliament has overreached its power, what are the role of a state assembly. One of the panelists was telling that in 75 years it has never happened that we have seen that a state is, the status is changed without the consent of the state, without the approval of the state assembly. Yes, this is for the first time. Then there are various aspects. What is whether this should have been passed by simple majority or by the majority where states have to approve it. All these aspects. When in 1957 the Constituent Assembly it is abolished. At that point of time, what was the intention? Whether it was there, if they could have done it, they would have done it. So their intention was that it should become a permanent feature. So all those kind of things, 35A, very relevant. What will happen to those? All those things are very, very crucial today, and we will see how our this constitution bench works out the formula as to what will be the answer to all these questions. Because prima facie, if you see it from the legal point of view, I would be very, very straightforward and candid on it that what is the role of state assembly, whether that has been followed. The mandate of the constitution is whenever there is a state status is changed, the proposal should come from the state assembly. Whether it has happened, no. And suddenly this particular thing is being done. And of course, on the other hand, we have, if you see the voice of the people was that this article should go. This article should go. And what are the results?
I want to ask you.
Mr. Chadda, my colleague Brajesh Pandey has a question for you.
Mr. Chadda, you very articulately put forward as to the kind of danger this particular scenario has in the future because the state will was not taken. And do you think it is? Legally, can we start giving importance to what people on the ground think, rather than what is the procedure or the norms which is laid down by the Constitution?
There are two set of arguments in this. Very thankful for this very nice question, I must say. First is law is dynamic. One set of people will say law is dynamic, it is not static. And what is the purpose of the law? The purpose of the law is to cater the society. It is not that it is meant and then it has to be strictly followed. And we have seen series of changes happen in laws in various, during last 75 years, we have seen laws have changed. Why? To serve the society. But on the other hand, legally speaking, yes, it cannot be done. First, you change the law and then you can apply it. You can't apply it and then subsequently think of changing it.
Yes, and there's one more question follow-up. Yeah, please.
One very important angle, which is very important, again, the legal aspect is, if I put across the governor, now who's the lieutenant governor, the post of governor at that point of time, he has taken oath under the constitution of J&K. Whether he can propose to abolish that, whether he can do that, anything, under which he has taken the oath and he abrogates it.
I wouldn't,
so that is another
Mr. Chadda, I wouldn't say this is a breaking news, but I think you should also have a look at it. I haven't used the word defeatist, which a lot of my colleagues in newsroom are saying, but I'm going to put that tweet on air. I'm going to put that tweet on air. I'm not going to use it. Newsroom speaks differently, but this tweet is by Mr. Sibbal. I'm putting it on air. Some battles are fought to be lost. For history must record uncomfortable fact for generations to know the right and wrong of institutional actions will be debated for years to come. History alone is the final arbiter of the moral compass of the historic decision. I am not trying to read anything, when my news editor called me.
You don't have to read anything. It is very clear. You don't have to read anything.
He is preempting it.
कुछ newsroom के कुछ लक्ष्मण रेखा है और studio के कुछ लक्ष्मण रेखा मैं पार नहीं करना चाहता, लेकिन ये मैं पढ़वाना जरूर चाहता हूँ. I want to put this on air.
I mean, there is no Lakshman Rekha to be crossed.
I want to put this on. I want to put this on air. Now, let me go back to something which is directly related to people. You see, it's like this. When temples, Kashi Vishwanath got renovated, people saw it from political perspective. And I was talking to Brijesh, and both of us agreed that there are things certain which need to be put in perspective from a pilgrim's perspective also.
Karthike, there is.
Just let me complete my argument. So in this case, there is another perspective. Can you play out the visuals of G20 and tourism? Okay, G20 and tourism. Aditya, I'll come back to you, Brijesh. I'll just come back to you. Tourism increased, pelting went down, stone pelting went down.
Absolutely.
Tourism increased. Yes, attacks have taken place. I'm not saying that it has become a paradise, but there are markers which are showing us that the economic activity was spurned. Yes, lot of investment didn't come, when you interviewed the Lieutenant Governor, when I interviewed it, but at least that commitment was shown. Micro entrepreneurial activities also mushroomed in places like Srinagar, or those apple belts which were created in Pulwama. So there is a part of 370 which cannot be discounted, and most important of all, if you see it from the rubric of G20. Aditya.
Absolutely, Karthikeya. There are two aspects to keep in mind. One is that normalcy in a conflict area is always difficult. And when you have taken a tough decision and you need to have a consistency in place, it takes a lot of time. Secondly, I think one of the mistakes that the government had done at that particular time was that a lot of chief ministers came in and said that now that 370 nullification has happened, terrorism will come down. Now, terrorism and 370 had nothing to do with each other. Terrorism is an external factor, Pakistan-sponsored terror, and an internal factor from radicalization. So terrorism will continue. But still we see that now 370 nullification has happened, the graph of violence has drastically come down. The number of terror attacks, the number of people radicalized, the number of infiltration attempts, the number of encounters have drastically reduced in the last 4 years, Karthikeya. So yes, there's been a change down on ground, but as I said, it's seen more than 40 years of conflict. That will not change overnight. It will take time.
Okay.
But at the same time, economic upliftment has happened. As you correctly mentioned, I was also part of one organization which had organized a Kashmironomics, conclave back in 2019. But it's very difficult to convince entrepreneurs and large business houses to invest in Kashmir, where, anytime there could be a terror attack or any moment there is intimidation or threats from the separatists. Although there are a lot of hotel chains, a lot of hospitals that have gone, and personally I have visited Kashmir at least 5 to 6 times every year. ever since abrogation. I was there when the abrogation happened. There's been a remarkable difference. The number of tourists, the kind of traffic jams that I'm witnessing in Srinagar, and the prices of hotels and flights is massive.
You know, that is one debate I think, you know, I'll have it with you. You know, the government really needs to do something about it, Aditya.
Absolutely.
They're exorbitant. It's, matlab, you know, I can plan the entire
Why?
trip of my family.
Why
to
don't you
Cambodia.
allow market to run? It's like you
No,
allow
there is
it to happen
there is
any
another
other
issue.
way.
No, there
Why
is
would you want the market to be capped
Rajesh,
just because you are feeling the
there
pinch,
is another issue. I feel that there is a cartel which controls the prices. You go
That's
to Cambodia, any part of Southeast Asia, the travel is so cheap. But in Srinagar, it's like 20,000, 25,000, you know. And this is live proceedings from the court. Live proceeding from the court. The stream is on. The stream is on. Not the reading out of the judgment. We will not jump to the conclusion. My colleague Brijesh will lay it out for you how this delivery will happen. Please explain it to
Well,
our
I think, you know,
viewers.
first the 5 judges will come, all the judges led by Chief Justice D.Y. Chandrachud, and post that they will start, first they will call out the case and then they will start delivering the verdict. What happens is that if there is a unanimous verdict, if all the 5 judges agree on one particular judgment, then the Chief Justice will rule out and there is going to be only one ruling. But if there is a 3-2 or 4-1,
you know, just for our viewers, you know, this is where the judges will sit, the honorable judges will sit. These are other 2 streams, you know, the petitioners and the you know, people who argued on behalf of the government. This is how it looks like, you know, all the mighties, you know, that's where they have to be when the judgment by the CJI is. Can we have it on? Can we have it on the full screen? You know, this part of it. This is where the Chief Justice of India will sit. We will know in the beginning. We will know in the beginning whether it's a unanimous judgment or not. Because if it's a unanimous judgment, I think CJI will announce it.
if there's a unanimous judgment, yes, only one judge will announce the verdict, which is the Chief Justice. But if there's a differing verdict, suppose 3-2, and the other 2 judges are also not in consonant with each other, what will happen is that first the Chief Justice will deliver the verdict, and then the other dissenting judges will do it. If it is 2-3, then these judges will first deliver their verdict, and then the remaining judges will deliver their own verdict as to what they think of this particular case. So it'll be very interesting to see, you know, how it pans out, and you know, all eyes, not only our studio's eyes, but I think, you know, the whole country as well as worldwide, people would be glued to this screen to listen to what the judges have to say on the 2 basic issues. Because, you know, Karthike, as you pointed out, you know, one of the key things which is which can open Pandora box for future is whether the parliament can subsume the role of state legislature. Because if that happens, then the situation is going to be very, very tricky, because any government with absolute majority can do whatever it wants as far as the parliamentary form of democracy is concerned.
You know, before being a journalist, you know, you have been in a different avatar. You have been in, I'll go to, Sanjay Chadda also joins me. You go to a different avatar. Leave aside a journalist in you, Aditya, just as a person. What do you feel about this judgment being read today?
Well, although, you know, people will not agree with me, but I personally feel that it will be a positive judgment supporting the nullification of 370, at least by majority. And secondly, I feel that there could be some strong remarks on 2 aspects. One is the elections that are to be held in Jammu and Kashmir and that are pending as of now. And I also feel that second important aspect to people of Jammu and Kashmir is statehood. So on statehood and on pending elections, there could be some strong remarks, although in which context and how the Chief Justice brings in this is important. Of course, because of the security scenario, he cannot lay out a timeline also of when the election should be, but perhaps there could be a message from the Supreme Court that the elections and democracy needs to be restored completely in J&K, and the statehood needs to be returned. That's already a commitment the Home Minister Amit Shah has laid out inside the parliament, that statehood needs to be restored. But otherwise, I feel that this was temporary in nature, it's a legality, and Supreme Court finally today, in a historic judgment, will completely seal it.
Okay. Mr. Chadda, I think it's a political question. I know you can answer it, you know. If you look at BJP's manifesto, Ram Temple is done. That's it. It's going to be a reality in January. 370 is today. I'm not being presumptuous. Going by Mr. Sibbal's tweet, I think I think it's pretty indicative of what's going to come. UCC remains. You think that's going to happen before 2024 elections, or that's for the third tenure of Prime Minister Modi?
If you ask me, not only Mr. Sibal, but majority of the people of India know that this judgment is going which way. Even other people sitting out here have said so. And now, as far as the UCC is concerned, I feel UCC is made more of a, something hype. What I feel, you will be shocked to know that majority of the civil code is already common. If you have to recover something from somebody, you can go and file cases. Only three things as far as the Uniform Civil Code is concerned, the personal laws are concerned, only those are covered in UCC, which is pertaining to marriage, pertaining to succession, maintenance, etc. And it is more of a very, I feel these are the only 3-4 aspects which are covered in UCC as such common civil code, which is different between the different communities. Otherwise, civil law is same. You have to recover some money from somebody. You have to see some land is encroached by somebody. Everybody has to, whether I am a Muslim or a Hindu, I have to follow the same law. The law is absolutely same, except for these three things which I just mentioned. So certainly, and I feel because there is some positive aspects of UCC, there's no doubt about it. And that is the reason our judiciary is continuously pursuing it. Our constitution makers have seen that vision that it should be one common civil law. So even I feel that that is the necessity, need of the hour, with certain restrictions. Something which are very crucial here is what is common here in Hindus in Uttar Pradesh or North India, it cannot be the same in Kerala. So there are certain diversities are there, no doubt about it. So similarly, we will create the UCC should be created with certain exceptions. So all those things which people say that Muslims have those things, they will never be following it and something of that sort. I think if we create certain exceptions, they will be following it. After all, law, and that is where I say always that this is the development of law. This is how we. This is another example of progressive society. So yes, politically I can't evaluate that, but UCC is the need of our, no doubt about it.
Before the proceedings commence, before the honorable judges come, let me play out a couple of more reactions and a ground report from our reporter.
जम्मू कश्मीर से आर्टिकल 370 हटाए जाने के केंद्र सरकार के फैसले के खिलाफ सुप्रीम कोर्ट में दाखिल याचिकाओं पर आज फैसला आएगा। इस मामले में याचिकाकर्ता हमारे साथ हैं, जो सुप्रीम कोर्ट के वकील भी हैं, अश्विनी उपाध्याय जी। सबसे पहले याचिका आपकी ओर से ही दाखिल की गई थी जब ये आर्टिकल हटाया नहीं गया था, क्या हुआ और उन याचिकाओं में आपकी ओर से क्या मांग की गई, इस बारे में हमें बताएं।
देखिए, हम लोगों ने 2014 में पीआईएल फाइल करके सुप्रीम कोर्ट में आर्टिकल 35A और आर्टिकल 370 दोनों को चैलेंज किया था। आर्टिकल 35A को इसलिए चैलेंज किया था कि वो कभी पार्लियामेंट के थ्रू गया ही नहीं, उसमें कभी पार्लियामेंट वोटिंग नहीं हुई, ना पार्लियामेंट पे उस पर कभी रेजोल्यूशन आया। वो सिंपल एग्जीक्यूटिव ऑर्डर से आर्टिकल 35A ऐड कर दिया गया था। आर्टिकल 370 हमने इस आधार पर चैलेंज किया था कि वो एक टेम्परेरी प्रोविजन था, वो 5 साल के लिए था।
हाँ, जो कॉन्स्टिट्यूएंट असेंबली ने लागू किया था
उतनी समय के लिए था, उसके बाद उसको कंटिन्यू रखना वो पूरी तरीके से इलीगल था। इस आधार पर हमने चैलेंज किया था। और आप फैक्चुअल आंकड़े ये बताते हैं कि जो कश्मीर में आतंकवाद था, अलगाववाद था, पत्थरबाजी थी, कट्टरवाद था, जिहाद था, मजहबी उन्माद था, उसका एक बहुत बड़ा कारण आर्टिकल 370 था। कश्मीर में जो डेवलपमेंट नहीं हो पा रहा था, उसका बहुत बड़ा कारण आर्टिकल 370 था। कश्मीर में जो करप्शन बहुत ज़्यादा था, सरकारी पैसे की बंदरबाट हो रही थी, केंद्र सरकार का 50% जो बजट जाता था वो केवल नेता अपने घर में रख लेते थे, उसका बड़ा कारण आर्टिकल 370 था। तो इसलिए जब केंद्र सरकार ने फैसला वापस ले लिया तो हम लोगों की पिटीशन इन्फेक्चुअस हो गई, मतलब एक तरीके से वो डेड हो गई। लेकिन जैसे ही लोगों ने केंद्र सरकार के फैसले को चैलेंज किया तो सुप्रीम कोर्ट ने हम लोगों की पिटीशन को रिवाइव कर दिया।
कितनी कुल याचिकाएं थी जो पक्ष में थी?
कुल टोटल 23 याचिकाएं हैं। 11 याचिकाएं हैं जो हम लोगों ने आर्टिकल 35 और 370 को चैलेंज किया था, 12 याचिकाएं थी जिन्होंने केंद्र सरकार के 370 हटाने के फैसले को चैलेंज।
यानी कि एक तरह से केंद्र सरकार ने जो फैसला लिया उसके पक्ष में कुल 11 याचिकाएं और जो 12 याचिकाएं केंद्र सरकार के फैसले के खिलाफ सुप्रीम कोर्ट में सुनी गई और अब आज उस पर फैसला आने वाला है। क्या उम्मीद करते हैं, क्योंकि केंद्र सरकार ये स्पष्ट कर चुका है कि घाटी से टेररिज्म पूरी तरह से खत्म किया जा चुका है और विकास वहां पर हो रहा है।
पहली बात तो मुझे पूरा विश्वास है कि सुप्रीम कोर्ट आज केंद्र सरकार के फैसले पे अपना स्टैंप लगा देगा। सुप्रीम कोर्ट जो आर्टिकल 370 खत्म हुआ है और आर्टिकल 35A खत्म हुआ है उसको वैलिड करार देगा और अब दोबारा आर्टिकल 35A 370 कभी रिवाइव नहीं हो पाएगी। उसका एक बहुत बड़ा कारण यह है कि पिछले 3 साल में जब से आर्टिकल 370 खत्म हुआ, आर्टिकल 35A खत्म हुआ है, उसके आंकड़े भी हैं कि किस तरीके से वहां आतंकवाद, अलगाववाद, कट्टरवाद, जिहाद, मजहबी उन्माद, पत्थरबाजी कम हुई है, किस तरीके से सरकारी योजनाओं का लाभ वहां बढ़ा है, किस तरीके से वहां पे टूरिज्म बढ़ा है, शांति आई है,
लेकिन
घटनाओं में कमी आई है।
लेकिन जो केंद्र सरकार के फैसले को चुनौती देने वाली याचिकाएं हैं उसमें सीधे तौर पर कहा गया है कि प्रोसेस में फ्लॉ किया गया, यानी कि जब विधानसभा को भंग किया गया उसकी शक्ति जो है संसद के पास नहीं थी। क्या ऐसा है?
नहीं, उन्होंने अपनी तरफ से इस दलील को रखा था, लेकिन मुझे नहीं लगता कि सुप्रीम कोर्ट उससे बहुत कन्विंस है। इसलिए हमें पूरा भरोसा है सुप्रीम कोर्ट का फैसला 100% इस बात पे आएगा कि आर्टिकल 35 जो हटाया गया बिल्कुल सही हटाया गया, 370 जो हटाया गया बिल्कुल सही हटाया गया। इसलिए जो लोग सपना देख रहे हैं कि नहीं आर्टिकल 35 रिवाइव हो सकता है, 370 रिवाइव हो सकता है, उनका सपना सपना ही रहेगा, वो कभी हकीकत में नहीं बदलेगा।
देखिए, हमने तो सारी उम्मीदें कोर्ट से रखी हैं और शायद मुझे लगता है हम पहले पिटिशनर थे जो कोर्ट गए थे पार्टियों में से, और हमारा अभी भी यकीन कोर्ट में ही है कि अल्लाह करे कि जो फैसला है वो जम्मू कश्मीर के लोगों के हक में हो। देखिए, नॉर्मल सर्कमस्टांसिस में जो कोर्ट होता है, कोर्ट इससे बालातर होता है, उसका इमोशन से, पॉलिटिक्स से कोई लेना देना नहीं होता है। मैं जो एक नॉर्मल एक डेमोक्रेसी में जो कोर्ट की हैसियत होती है उसका इससे कोई लेना देना नहीं होता है कि मेजॉरिटी ओपिनियन क्या है, माइनॉरिटी ओपिनियन क्या है, वो कानून से जाती है और हमें जो लगता है कि कानून हमारे हक में होना चाहिए। तो एडमिनिस्ट्रेशन को मैं बताना चाहूँगा, ये जो डेमोक्रेसी है ना, ये पार्ट कॉन्सेप्ट नहीं है, ये एक फुल कॉन्सेप्ट है। ईदर यू हैव इट और यू डोंट हैव इट। या आपके पास डेमोक्रेसी है या आपके पास डेमोक्रेसी नहीं है। अगर ग्रास रूट पर की है तो क्या इसका ये जवाज़ है कि जो टॉप लेवल पर है, जो डिसीजन मेकिंग है, जहाँ लॉज बन सकते थे, जहाँ पूरी स्टेट चलाई जा सकती है, वहाँ ना रखें, वो कैसी डेमोक्रेसी होगी? ऊपर से नीचे तक द एंटायर पिरामिड ऑफ डेमोक्रेसी हैज़ टू बी वाइब्रेंट और जो काम करे, राइट? तो ये ड्रामा जो है कि नहीं जी हमने ग्रास रूट डेमोक्रेसी को स्ट्रेंथन किया, ईदर यू हैव इट और यू डोंट हैव इट। देखिए, जो भी यहाँ एडमिनिस्ट्रेशन है, अपार्ट फ्रॉम जो ऑफिसर्स हैं, राइट, वो तो एक सिस्टम के तहत हैं, उनका कोई जवाज़ नहीं बनता है, डेमोक्रेटिक कॉन्स्टिट्यूशनल जवाज़ नहीं बनता है यहाँ बियॉन्ड अ सर्टन टाइम गैप यहाँ होना। यहाँ जम्मू कश्मीर के लोग ने जिनको चुने, चाहे हमारे सियासी हरीफ को चुने, किसी को भी चुने, एनी डे दैट इज़ बेटर देन व्हाट वी हैव।
370 धारा एक टेम्पररी मेजर लगाई गई थी। खुद पंडित जवाहरलाल नेहरू जी ने कहा था उस समय पर जब जम्मू और कश्मीर पे काफी विवाद चल रहा था। हमारी मान्यता स्पष्ट ये थी, शिवसेना की भूमिका ये रही है कि 370 को हटाने का समय आ गया था और वो हटाया गया। उसके चलते जो वादे भारतीय जनता पार्टी ने किए थे, जब हटाया गया तो हम उसके समर्थन में थे, पर वादा ये किया गया था कि प्रजातंत्र बहाल होगा, वहां पे इलेक्शंस जल्द से जल्द होंगे, जनता की सरकार बनकर आएगी, जो आतंकी हमले हैं वो खत्म होंगे, कश्मीरी पंडित भाई बहन, जो हमारा एजेंडा बाला साहेब ठाकरे जी के समय से रहा है कि वो वापस अपने घर पहुंचे, वो पूरा करेंगे। पर मैं खुद ही जम्मू गई थी जब टारगेटेड किलिंग के शिकार हमारे कश्मीरी पंडित भाई बहन हुए हैं, तो उनके साथ जो नाइंसाफी अब तक चल रही है वो दुर्भाग्यपूर्ण है। और जो वादा किए थे 370 हटाने के बाद वो आज तक पूरे नहीं किए गए हैं, वो मैं मानती हूँ जनता के साथ एक खिलवाड़ हुआ है।
हमें पूरी उम्मीद है कि सुप्रीम कोर्ट संविधान के मुताबिक फैसला करेगी, कश्मीर के लोगों के जज्बात को नज़रअंदाज नहीं किया जाएगा, सुप्रीम कोर्ट का जो भी फैसला आएगा उसका सम्मान किया जाएगा। निश्चित तौर से कश्मीर का मामला है और 370 जिस तरीके से ख़त्म किया गया था, तमाम कश्मीर के नेताओं को जेल में डालकर 7 लाख 8 लाख फौज लगा के एक एक घर पे फौजी खड़ा करके इस तरीके से कभी ना कोई कानून बनाया जाता है ना ख़त्म किया जाता है। निश्चित तौर से कश्मीर के लोगों के जज्बात को ठेस पहुंची है। अब सुप्रीम कोर्ट संविधान के मुताबिक क्या फैसला करता है, इसका इंतज़ार पूरे देश को नहीं है, पूरी दुनिया को है।
See, this is a very important, significant issue which is to be decided by Supreme Court. And Supreme Court has heard the matter at length, and people of Jammu and Kashmir are expecting a lot from the Supreme Court. And we believe that Supreme Court will rightly uphold the Constitution as well as the sentiments of the people. All rights of the people of Jammu and Kashmir, which were protected earlier with regard to land and jobs, they were abruptly, unilaterally and democratically taken away. His state was downgraded and disbanded, divided into two UTs, and elections have not been held for the last 5.5 years, more than 4.5 years after the abrogation of Article 370 also. Ladakh got a UT, but you are ready to discuss certain layers, safeguards for land and jobs and their identity. But you are not ready to discuss that for Jammu and Kashmir, the rest of the UT. It was one state. So people demand restoration of statehood, early elections, democracy is not there. And what is happening on Article 370, that will be seen. We can only comment after the judgment comes. We respect the rule of law at the Supreme Court. People have high hopes from the Supreme Court. Ultimately, let's see what is happening.
ये पूरी तरह से निराधार है। पूरे जम्मू कश्मीर में न ही किसी को हाउस अरेस्ट किया गया है, न ही किसी की गिरफ्तारी की गई, और ये भ्रामक अफवाह फैलाने की कोशिश है। मैं बड़ी जिम्मेदारी से बात कर रहा हूं कि पूरे जम्मू कश्मीर में राजनीतिक कारणों से किसी को न गिरफ्तार किया गया है, न हाउस अरेस्ट किया।
देखो, टुडे the question which has to be decided by the constitutional bench of Supreme Court of India is that whether the state assembly can exercise all those powers which are available to the constituent assembly of Jammu and Kashmir. So if constituent assembly power can be exercised by the legislative assembly for TRE, this will apply to the parliament as well. In earlier judgment of Keshavananda Bharati, the Supreme Court has held that Parliament under its constitute power cannot exercise all those powers which were available to the Constituent Assembly of India. Therefore, a limit has been imposed that the Parliament is guided by the Constitution because it draws its power by the Constitution. So here, the same question is again before the constitutional bench. The second most important question which has to be decided today for the first time by the constitutional bench of the Supreme Court is whether is it permissible that without the opinion of the state assembly can you disintegrate a state and remove it from the map of India as a state and bifurcate into two union territories? So that is the moot question before the Honorable Supreme Court, and we hope that the Supreme Court will decide and do justice with the people of Jammu and Kashmir. We are hopeful that the Supreme Court will decide in our favor. So anything which is, unless it is announced by the Supreme Court, we cannot say anything with certainty, but we are hopeful. The people of Jammu and Kashmir as a whole are very hopeful that the Supreme Court will decide in our favor.
धारा 370 पे माननीय सुप्रीम कोर्ट के फैसले का इंतज़ार है। मैं इतना ही बोलना चाहूँगा आपको, आपकी चैनल की वसादत से पूरे मुल्क को मैं बोलना चाहूँगा कि हम जम्मू कश्मीर और लद्दाख के बाशिंदे मुंतज़र हैं कि माननीय सुप्रीम कोर्ट सही फैसला करेगी कल और वो जस्टिस देंगे जम्मू कश्मीर और लद्दाख के अवाम को, क्योंकि 370 की धारा एक ऐसी धारा है जो एक सतून का काम करती है कॉन्स्टिट्यूशन ऑफ इंडिया के लिए, और एक ये बेसिक बेसिक धारा है, एक बेसिक प्रिंसिपल है हमारे कॉन्स्टिट्यूशन का। इसको तोड़ना या इसको रद्द करना कोई मामूली चीज़ नहीं है। इससे आप नहीं तो पूरा जो हमारे फोरफादर्स ऑफ मॉडर्न इंडिया हैं, जिन्होंने हमको कॉन्स्टिट्यूशन दिया, ये मुल्क दिया, आप उनके फैसले को चैलेंज कर रहे हैं, आप इंस्ट्रूमेंट ऑफ एक्सेशन को चैलेंज कर रहे हैं। कल फैसला उम्मीद है कि जिस तरह से ये केस हमने ऑलरेडी जीता हुआ है एज पर द आर्ग्यूमेंट्स दैट वर पुट फोर्थ बिफोर द ऑनरेबल सुप्रीम कोर्ट, कल को कुछ भी एडवर्स फैसला आ सकता है, हो सकता है एडवर्स आए। हमारे पास विकल्प खुले हैं आइंदा कानूनी कार्रवाई के लिए। हो सकता है अपने जो उम्मीद रख रहे हैं बीजेपी के हमारे साथी, ये फैसला उनके खिलाफ जाए। दे ऑल्सो हैव एक्सेस टू अदर लीगल।
Now the judges have come. Let's go directly to the Supreme Court of India.
Justice Gavai and Justice Surya Kant. There is a concurring opinion authored by Justice Sanjay Kishan Kaul. Justice Sanjeev Khanna has concurred with both the judgments. The reference before the Constitution bench raises the following questions for determination. A, whether the provisions of Article 370 were temporary in nature or whether they acquired a status of permanence in the Constitution. B, whether the amendment to Article 367 and exercise of the power under Article 371D was to substitute the reference to the Constituent Assembly of the state referred to in Clause 3 of Article 370 by the words Legislative Assembly of the state is constitutionally valid. C, whether the entire Constitution of India could have been applied to the state of Jammu and Kashmir in exercise of the power under Article 370, Clause 1, bracket D. D, whether the abrogation of Article 370 by the President in exercise of the power under Article 370, Clause 3 is constitutionally invalid in the absence of a recommendation of the Constituent Assembly of the state of Jammu and Kashmir as mandated by the proviso to Clause 3. E, whether the proclamation of the Governor dated 20 June 2018 in exercise of power conferred by Section 92 of the Constitution of Jammu and Kashmir and the subsequent exercise of power on 21 November 2018 under Section 53(2) of the Constitution of Jammu and Kashmir to dissolve the Legislative Assembly are constitutionally valid. F, whether the proclamation which was issued by the President of India under Article 356 of the Constitution on 19 December 2018 and the subsequent extensions are constitutionally valid. G, whether the Jammu and Kashmir Reorganization Act 2019, by which the state of Jammu and Kashmir was bifurcated into two union territories, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh, is constitutionally valid, bearing in mind, 1, the first proviso to Article 3, which requires that a bill affecting the area, boundaries, or name of a state has to be referred to the legislature of the state for its views. And 2, the second proviso to Article 3, which requires the consent of the state legislature for increasing or diminishing the area of the state of Jammu and Kashmir, or altering the name of the boundary of the state before the introduction of the bill in Parliament. H, whether during the tenure of a proclamation under Article 356, and when the Legislative Assembly of the state is either dissolved or is in suspended animation, the status of the state of Jammu and Kashmir as a state under Article 1(3)(a) of the Constitution and its conversion into a union territory under Article 1(3)(b) constitutes a valid exercise of power. I'll now read out our conclusions under different heads. Whether the proclamation issued under Article 356 of the Constitution of India and Section 92 of the Constitution of Jammu and Kashmir is constitutionally valid. We have held that this court need not adjudicate on the validity of the proclamations because, 1, the pleadings of the petitioners in the writ petitions indicate that their principal challenge is to the abrogation of Article 370 and whether such an action could have been taken during Precedent's rule. And 2, even if this court holds that the proclamation could not have been issued under Article 356, there would be no material relief which can be given in view of the fact that Precedent's rule was revoked in the state of Jammu and Kashmir on 31st October 2019. Further, the petitioners have assailed the specific actions which were taken when the proclamation was in force on the ground that those actions breached the constitutional limitations on the exercise of power after a proclamation under Article 356 is issued. These substantive challenges, which form the fulcrum of the case of the petitioners, have been considered. Next issue, whether there are limitations on the exercise of power by the President or Parliament under Article 356. We have held that there are limitations on the power which can be exercised by the Union government in the state when a proclamation under Article 356 is in operation. We have reached the conclusion on the following grounds. A, the majority in S.R. Bommai, the 9-judge bench decision, held that the actions taken by the President after issuing a proclamation are subject to judicial review. However, the learned judges adopted slight variations on the standard needed to be applied by the court to test the validity of the exercise of power by the President after the issuance of the proclamation. Justice Sawant applied the standard of whether the exercise of power was mala fide or palpably irrational. Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons. First, the thread that runs through Part 18 of the Constitution, when read as a whole, is that differing levels of executive and legislative power are required to handle an emergency under Article 352 and under Article 356. This principle applies to the exercise of power when a proclamation under Article 356 is in force. Second, Article 356(1) states that the President may, by a proclamation, assume or declare the powers stipulated in clauses A, B, and C of Article 356(1). The powers stipulated in clauses A, B, and C of Article 356(1) are not automatically invoked when a proclamation is issued under Article 356. Third, Article 356(1)(a) does not opt for an all or none formula. The phrase all or any does not indicate that the Union government can exercise a part of the functions of the state government and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the Union government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B, and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the principle which runs through Article 356(1)(c) and which also guides the exercise of power under Article 356(1)(a) is that the exercise of power must have a reasonable nexus with the object of the proclamation. And sixth, when a proclamation under Article 356 is in force, there are innumerable decisions which are taken by the Union government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by the Union executive on behalf of the state is not subject to challenge. Opening up challenge to every decision would lead to chaos and uncertainty. It would in effect put the administration in the state at a standstill. Therefore, the following standard is laid down to assess actions under Article 356 after the proclamation has been issued. A, the exercise of power by the President under Article 356 must have a reasonable nexus to the object of the proclamation. B, the person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. After a prima facie case is made, the onus shifts to the Union to justify that the exercise of power had a reasonable nexus with the object of the proclamation. And C, The exercise of power by the President for everyday administration of the state is not ordinarily subject to judicial review. The argument of the petitioners that the Union government cannot take actions which have irreversible consequences when a proclamation under Article 356 is in force is not accepted. The power of the legislature of the state under Article 357 to repeal or alter or amend a law enacted by Parliament in exercise of the power of the legislature of the state must be read in the context of the amendment introduced by the Constitution, 42nd Amendment Act 1976. Before the amendment, the law to the extent of incompetency would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would in such case make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356 because an ordinance which has the effect of a law by its very nature has a limited life. The argument of the petitioners that Parliament can only assume the lawmaking powers of the legislature of the state when the proclamation under Article 356 is issued is not accepted. The purpose of Article 357 is to ensure that while exercising the powers of the legislature of the state, pursuant to a declaration under Article 356(1), Parliament, or as the case may be, the President, are not impeded by an absence of competence which would have impeded the exercise of a similar power in the absence of a proclamation under Article 356. Further, Article 357 does not contain a non-obstante provision which overrides Article 356. To interpret Article 357(1) as a restriction on Article 356(1)(b would be to read in a restriction which the plain terms of the Constitution do not provide. As held above, the exercise of power after a proclamation under Article 356 is issued is subject to judicial review, and immunity from judicial scrutiny does not attach to the exercise of constitutional powers of the legislature of the state. The court, while judicially reviewing the exercise of power, can determine if the exercise of the constitutional power of the legislature of the state by Parliament has a reasonable nexus with the object sought to be achieved by the proclamation. The next issue is whether Jammu and Kashmir retained an element of sovereignty or internal sovereignty when it joined the Union of India. We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, That the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination, as understood by the definition of sovereignty, exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Call was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. See, we have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. D. On the second question of the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370, we have held that the power of the President of India under Article 370, Clause 3, to issue a notification declaring that Article 370 ceases to exist, subsists even after the dissolution of the Constituent Assembly of Jammu and Kashmir for the following reasons. First, the proviso to Article 373, that is Clause 3, encapsulates the process by which the Indian states could ratify the Constitution of India. The ruler of each Indian state had to issue a proclamation ratifying the Constitution on the recommendation of the Constituent Assembly, where such body existed. In states where the Constituent Assembly was not convened by then, the ruler of the state had to issue a proclamation accepting the Constitution. When a Constituent Assembly was convened in those states, the Constituent Assembly could make a recommendation for the modification of the Constitution as it applied to the state and such a recommendation would be earnestly considered, into inverted commas, earnestly considered by the Union. The words recommendation of the Constituent Assembly referred to in clause 2 shall be necessary before the President issues a notification, as it appears in the proviso to Article 370, clause 3, and must be read in this context. Thus, the recommendation of the Constituent Assembly to begin with was not binding on the President. Second, at the time of the framing of the Constitution of India, it was obviously within the contemplation that the Constituent Assembly of Jammu and Kashmir was formed for framing the Constitution for the state. It was not intended to be a permanent body, but a body with a specific remit and purpose. The power conferred by the proviso to Article 370, Clause 3 was hence something which would operate in a period of transition when the Constituent Assembly of Jammu and Kashmir was formed and was in existence pending the drafting of the state constitution. Third, when the Constituent Assembly of Jammu and Kashmir ceased to exist, only one of the special circumstances for which the provision was introduced ceased. However, the other circumstances, that is the special circumstances because of the situation in the state of Jammu and Kashmir, for which Article 370 was introduced, subsisted even after the Constituent Assembly ceased to exist. This is recognized by the judgment of the Constitution Bench in Sampath Prakash. Fourth, the effect of the President declaring under Clause 3 of Article 370 that Article 370 ceases to exist is that the provisions of the Constitution which apply to every state in the first schedule would equally apply to the state of Jammu and Kashmir. Articles 370(1)(d) and 370(3) were introduced with the purpose of enhancing constitutional integration and not for the disintegration. So, the power under Article 370(1)(d) and Article 370 Clause 3, even when exercised to its fullest extent, does not freeze the system of integration contemplated by Article 370, but is rather intended to enhance constitutional integration between the Union and the state of Jammu and Kashmir. Holding that the power under Article 370 Clause 3 cannot be exercised after the dissolution of the Constituent Assembly would lead to the freezing of the process of integration, contrary to the purpose of introducing the provision. And 5, if the contention of the petitioners on the interpretation of Article 370 vis-à-vis the dissolution of the Constituent Assembly is accepted, then Article 370 Clause 3 would become redundant and would lose its temporary character. The President, while deciding if the power under Article 370 Clause 3 must be exercised, determines if the special circumstances which warranted a special solution in the form of Article 370 have ceased to exist. This is a policy decision which completely falls within the realm of the executive. The court cannot sit and appeal over the decision of the President of India on whether the special circumstances which led to the arrangement under Article 370 have ceased to exist. However, the decision is not beyond the scope of judicial review. It is settled law that the exercise of executive power can be challenged on the ground of malafides. The slew of constitutional orders issued by the President under Article 370(1)(d), applying various provisions of the Constitution and applying provisions with modification, indicate that over the course of the last 70 years, the Union and the state have, through a collaborative exercise, constitutionally integrated the state of Jammu and Kashmir with the Union. This is not a case where only Articles 1 and Article 370 of the Constitution were applied to the state of Jammu and Kashmir, and suddenly, after 70 years, the entire Constitution was being made applicable. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President in exercise of the power under Clause 3 of Article 370 is a culmination of the process of integration. Thus, we do not find that the President's exercise of power under Clause 3 of Article 370 was mala fide. Having concluded that the power under Article 370 Clause 3 subsisted even after the dissolution of the Constituent Assembly, we have held that the exercise of power by the President to issue CO 273 is a valid exercise of constitutional power. The next issue is the challenge to CO 272 on the ground that the power under Article 371D cannot be issued to apply all the provisions of the Constitution to the state of Jammu and Kashmir. We have held that all provisions of the Constitution can be applied to Jammu and Kashmir through the exercise of power under Article 371D. The power under Article 371D can be used to apply one provision, more than one provision, an entire part of the Constitution, or all the provisions of the Constitution, that is the entire Constitution. The provision does not make a distinction between one or all provisions of the Constitution. Non-application of mind cannot be claimed merely because CO 272 applies all provisions of the Constitution to Jammu and Kashmir in one go. The next issue is the challenge to CO 272 on the ground that the President could not have secured the concurrence of the Union government under the second proviso to Article 371D. We hold that the President seeking the concurrence of the Union government instead of the government of the state to issue CO 272 is not invalid because, first, the effect of applying all the provisions of the Constitution to the state of Jammu and Kashmir through the exercise of power under Article 371D is the same as an exercise of power under Article 370, Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. Second, consultation and collaboration between both the units will only be necessary where the application of the provisions of the Indian Constitution to the state would require amendments to the state constitution, because the purpose of the requirements of consultation and collaboration is for the smooth functioning of governance in the state and to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent with the provisions of the Constitution of India. Third, since the effect of applying all the provisions of the Constitution of Jammu and Kashmir, since the effect of applying all the provisions of the Constitution to Jammu and Kashmir through the exercise of the power under Article 371D is the same as issuing a notification under Article 370, Clause 3, which the President has the power to unilaterally issue, the principle of consultation and collaboration are not required to be followed. Fourth, the exercise of power is mala fide only if power was exercised with an intent to deceive. Deception can only be proved if the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The next issue is the challenge to CO 272 on the ground that it is ultra vires Article 371D because it modifies Article 370. We have held that the modification by CO 272 to Article 367 as it applies to Jammu and Kashmir had the effect of amending Article 370 and is thus ultra vires Article 370(1)(d). We have reached this conclusion for the following reasons. First, recourse must be had to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. No other procedure may be utilized to amend Article 370. Second, the rule of interpretation that a power under a statute must be exercised in accordance with the provisions of that statute and in no other manner is undoubtedly applicable to the Constitution. Third, from precedent, including Shankari Prasad Singh, Sajjan Singh, Quixote Holohan, and Rajendra Shah, it emerges that the following aspects are of significance when assessing whether a change has been made to a provision of the Constitution. 1. A change may be either in terms of or in its effect. 2. A change can be said to have been made even if the language of the concerned provision is not directly amended by adding, subtracting, or modifying the language. This is a change in effect. And 3. If the effect of an amendment is to change a provision, such effect must be significant or appreciable. And 4. The substance of a change is more important than its form. Second, an assessment of whether a constitutional order amounts to a modification and consequently whether the procedure under Article 370, Clause 1 or under Article 370, Clause 3 ought to have been followed depends on this standard. Third, the effect of a provision of law is as important as its form. While the change sought to be made by paragraph 2 of CO 272 may appear to be a modification or amendment of Article 367 at first blush, its effect is to amend Article 370 itself. CO 272 changes the language to the proviso to Article 370, Clause 3 in two ways. First, it changes the recommending body from the Constituent Assembly to the Legislative Assembly. And second, it makes a new arrangement at variance with that specific Constituent Assembly. Both these changes are not insignificant because they modify the essential character of the proviso by substituting a particular type or kind of body with another type or kind entirely. Fourth, while the interpretation clause, namely Article 367, can be used to define or give meaning to particular terms, it cannot be deployed to amend a provision by bypassing the specific procedure laid down for its amendment. This would defeat the purpose of having a procedure for making an amendment to the Constitution of India. Fifth, the consequence of permitting amendments through the circuitous manner would be disastrous. Many provisions of the Constitution would be susceptible to amendments which evade the procedure stipulated by Article 368 or other provisions. Sixth, the previous constitutional orders which modified Article 370 through Article 367 were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3 by taking recourse to Article 367. G, the status of the Constitution of Jammu and Kashmir. The gaps left by the non-application of some parts of the Constitution of India were filled by the Constitution of the state. After the abrogation of Article 370, as it stood before the issuance of CO 272 and CO 273, and the application of the entirety of the Constitution of India to the state, the Constitution of the state does not fulfill any purpose or serve any function. Hence, the implicit but necessary consequence of the application of the Constitution of India in its entirety to the state of Jammu and Kashmir is that the Constitution of the state is inoperative. On the validity of Parliament's exercise of power under the first proviso to Article 3, this is what we have said. A five-judge bench of this court in Babulal Parate held that the views expressed by the legislature of the state under the proviso to Article 3 are not binding on Parliament. If the views of the state legislature were binding on Parliament, which is not the case, there would be scope for debate on whether Parliament, in exercise of its powers under Article 356 1b, could have substituted its views for the views of the Legislative Assembly of the state. However, the views of the legislature of the state are not binding on Parliament in terms of the first proviso to Article 3. The views of the legislature of the state under the first proviso to Article 3 are recommendatory to begin with. Thus, Parliament's exercise of power under the first proviso to Article 3 is valid and not mala fide. The next issue is on the validity of the suspension of the second proviso to Article 3 as applicable to Jammu and Kashmir. When the reorganization bill was introduced, that is on 5 August 2019, the second proviso to Article 3 as it applied to the state of Jammu and Kashmir ceased to exist because of CO 272. Thus, the issue of whether the second proviso to Article 3 could have been suspended in exercise of the power under Article 356 1c does not survive. The next issue is the validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary. The Solicitor General submitted that the status of the Union Territory of Ladakh will not be affected by the restoration of statehood to Jammu and Kashmir. In view of the submission made by the Solicitor General that statehood would be restored of Jammu and Kashmir, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two Union Territories of Ladakh and Jammu and Kashmir is permissible under Article 3. The status of Ladakh as a Union Territory is upheld because Article 3A, read with Explanation 1, permits forming a Union Territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The question of whether Parliament can extinguish the character of statehood by converting a state into one or more union territories in exercise of power under Article 3 is left open. In an appropriate case, this court must construe the scope of powers under Article 3 in light of the necessary effect of converting a state into union territories, which is that autonomy would be diminished, the historical context for the creation of federating units, and its impact on the principles of federalism and representative democracy. In view of the above discussion, the following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the Union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370, Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the provisor to Article 370, Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370, Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d). Recourse must have been taken to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of CO 272, by which Article 370 was amended through Article 367, is ultra vires Article 370, Clause 1, Clause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. H. The exercise of power by the President under Article 370(1)(d) to issue CO 272 is not mala fide. The President, in exercise of power under Article 370, Clause 3, can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union of the union government acting on behalf of the state government under the second provisor to Article 370(1)(d), while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Clause 3 of Article 370, for which the concurrence or collaboration with the state government was not required. I. Paragraph 2 of CO 272 issued by the President in exercise of power under Article 370, 1D, applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. J. The President had the power to issue a notification declaring that Article 370, Clause 3 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, Clause 3 is a culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. K. The Constitution of India is a complete code for constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of the state of Jammu and Kashmir is inoperative and is declared to have become redundant. L. The views of the legislature of the state under the first proviso to Article 3 are recommendatory. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not mala fide. M. The Solicitor General stated that the statehood of Jammu and Kashmir will be restored, except for the carving out of the Union Territory of Ladakh. In view of the statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two Union Territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the Union Territory of Ladakh in view of Article 3A, read with Explanation 1, which permits forming a Union Territory by separation of a territory from any state. N. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.
So, a very important development. Justice Chandrachud read the verdict. Well, there are other two verdicts which will be read.
Yeah.
We will put them out. So, it's very, very clear that Parliament has the sovereignty, Brijesh.
Well, absolutely. I think, the Chief Justice has completely agreed with everything that the centre has put forward and rejected every contention of the 23 petitions which were filed before it. It historically held that Article 370 is a temporary solution. It also said that the sovereignty with which what was talked about in relation to J&K lost its meaning. There was no sovereignty once it acceded to the Constitution of India. It also went on to say that the intention of the President was not mala fide, and they gave a detailed reasoning order about what all led them to come to this particular conclusion. And they have also said that since the government has promised them that steps are being taken to restore the statehood of J&K, which has been converted into a union territory, the Apex Court has asked the government to have a state election in the place by 30th September 2024. So I think, it's a big win for the government as far as abrogation of Article 370 is concerned. They have come out all trumps, and I guess a couple of other judges will also reason out and read out the orders they have written, because all the three orders, different orders, point towards one unanimous verdict.
Aditya.
Well, it's a historic verdict, really, Kartikeya. Firstly, the Chief Justice of India went into the details of the legality of what we were discussing till now.
I think another verdict is being read out. Let me just go back to the call.
Justice call.
Conclusions are same, except in one of the aspects of Premnath's call's case, I have taken a slightly different route, that's all. So the relationship between Union and State of Jammu and Kashmir, the concept of internal sovereignty after the IO, I am of the view that this question has been decided by the coordinate bench of this court in Premnath's call that the state did not lose all semblance of its internal sovereignty which would include deciding upon the forms of government of the state upon signing of the IO. The distinguishing feature as compared to the other states was that a slightly different path was followed for the accession of state of Jammu and Kashmir by recognizing the Constituent Assembly to be formed for the state. The route of assimilation of state of Jammu and Kashmir was through Article 370. Then I've heard that I've taken note of the various factors such as Article 370's historical context in the text and subsequent practice to conclude that Article 370 was intended to be a temporary provision. As a corollary, there was a mechanism to bring the whole arrangement to an end. The effect of the power under Article 373, once exercised, would be that the article shall cease to be operative. In other words, the mechanism was meant to de-recognize the state's internal sovereignty. Thus, the exercise of power under Article 373 meant that for purposes of the Constitution of India, only the Constitution of India would apply to the Jammu and Kashmir and not any other constitution, that is the Constitution of Jammu and Kashmir. The purpose, then on Article 373, I have said, the purpose of the Constituent Assembly was to draft a constitution for the governance of the state. On the other hand, the purpose of Article 370, as noted above, was to slowly bring Jammu and Kashmir on par with the states in India. It can hardly be contended that the second and in some ways a larger purpose would be effected by the fulfillment of the first. The second purpose remained an ongoing exercise long after the State Constituent Assembly was dissolved. Thus, the conditionality in Article 373 of the requirement of a recommendation from Constituent Assembly cannot be read in the manner as to make the reference to the larger intention of the provision redundant. B. The next question is to determine what process is to be followed by the President to exercise the power under Article 373. The President can exercise this power under Subclause 3 without a recommendation from the Jammu and Kashmir Constituent Assembly. When the Constituent Assembly ceased to exist, only the power of the Constituent Assembly to make the recommendation ceased to exist, that is, the proviso to Article 370 became otious. The main provision, which is the President's power to issue a declaration, continues to exist. C. Now coming to the impugned action, first the amendment of Article 373 through the route of Article 367 was invalid. When a methodology has been provided, that methodology would have to be followed and an amendment through the back door would be impossible. D. Concurrence with the government of the state was not necessary to apply all provisions of the Constitution of India to the state. Although Article 371D requires concurrence with government of the state, in this case, the governor of the state had dissolved the Legislative Assembly of the state. There were no Council of Ministers, and the President had reduced to himself all functions of the government of the state under the 2018 proclamation as extended. Then on the exercise of power under Article 356 were permissible while issuing COs 272 and 273.
I think it's a big decision. 370 stays. The power of the government of India, the Parliament to amend the law stays. What are its legal repercussions?
Okay. Karthikeya, let me tell you few things. Firstly, it's a unanimous verdict. But there are three judgments. The first judgment was delivered by the Chief Justice of India, as we just saw. He read the judgment on his behalf, Justice Suryakant and Justice Gawai. The other judgment is by Justice Sanjay Kishan Kaul and Justice Sanjeev Khanna. They are separate judgments, but they are concurring in their findings. The findings are clearly, number one, that abrogation of Article 370 was permissible as it was an exercise for integration of Jammu and Kashmir with India. Second, the court has said that Jammu and Kashmir, when they signed the instrument of accession, they lost all elements or even a shred of sovereignty or internal sovereignty, whatever it was. Because that was one of the arguments which was taken by the petitioners in the Supreme Court, was that this instrument of accession was more like shaking of hands and not just embracing the government of India, and the state of Jammu and Kashmir retained some degree of sovereignty. So Article 370 could not have been revoked without the prior concurrence of the State Legislative Assembly or the State Constituent Assembly. The third thing the court said was that Article 370 was a feature of asymmetric federalism and not sovereignty. Then they went on to say that the president had the power to subject the presidential power to revoke 370 is subject to judicial review and must have reasonable nexus to the objects it sought to achieve. The power is basically, they've again gone on to say that if you look at Article 370 from a historical context, it is a temporary provision. Now, this is very important because this is one thing that the court was called on to adjudicate, whether 370 is a temporary provision or a permanent provision. While the government of India took a stand that this is a temporary provision, and once the circumstances which make for its temporary in nature are effaced, then we can revoke Article 370 and integrate Jammu and Kashmir into the Union of India. Whereas the petitioner said that no, this is not a temporary provision, it's a permanent provision. The another thing is that the court said is that the presidential power revoking 370 was not malified. It was not illegal, it was not invalid. Now, they also said that the Constitution of India is a complete code of governance for this country, and the views of the State Assembly are just recommendatory in nature. Now, this has serious implications for future, because tomorrow if a State Assembly makes any recommendation to a subject matter in the concurrent list, it will only be recommendatory in nature and not binding on the Parliament or the central government. The most important thing here, Kartikeya, is the return to statehood of Jammu and Kashmir. The court says we direct the Election Commission of India to hold elections to the State Assembly by 30th September 2024. That's just after the general elections. And they also said that we direct the central government to restore statehood to Jammu and Kashmir as soon as possible.
Aditya.
Well, I think it's a historic judgment. I am happy because not just because I'm a journalist covering from Jammu and Kashmir, but covering Jammu and Kashmir for a long time. But Kartikeya, just as we discussed, I was hopeful, and something within me told me that 370 will have to go, and there will be strong comments on elections and statehood. I think it's amply clear the legality has been laid down. Ashok very brilliantly explained to us the main key points of what the Chief Justice of India said, and the main key point here is that it's a unanimous judgment. I mean, even if 1 or 2 points that Justice Kaul and Justice Khanna had a difference over, but the conclusion are completely unanimous. The main points as per me are that this was temporary in nature. It's a funny story, but back in 2006 when I was on a similar debate and we were discussing 370, some panelists of senior politicians from National Conference were laughing at me when I said that there will be a day when 370 will have to go, and they said no, oh, this is rubbish, this cannot happen. So I think that some of the politicians have got a reality check that 370 was a temporary notification, which the Chief Justice said was not only textual, but it was understood that it was for an interim process, and that process is over now. So apart from that, the Constitution Assembly or the J&K Assembly, whatever recommendations they make, they are recommendatory in nature. They are not to be followed completely.
They are not binding.
They are not binding by the Parliament or the President of India. So the President of India's intentions or President of India's order or proclamation is not malified in any nature. I think it's a very historic judgment in the history of Jammu and Kashmir. For decades together, the BJP was saying that they will nullify or abrogate 370. They made it happen in 2019. Then there was a legal process. It also is a defining moment for the history of India, I would say, because we have democratic mechanisms. There were grievances by National Conference, PDP, and 21 other parties, individuals and organizations. I think that has been met. There are other legalities and appeals that they can make now, but I think they need to understand now
that Article 370 is the past. What they really need to do now is to strengthen the democracy in Jammu and Kashmir, have elections perhaps by next year, and campaign for a statehood, but because that is a just right that they really deserve, the ordinary Kashmiris really deserve. Also, Karthikeya, that I want to lastly point out is that 370 was some kind of a bargaining chip. 370 was a pressure tactic by the NC, PDP and also the separatists to say that we are special, that we are not like ordinary Indians, we need to be treated specially. That is over now. Any kind of a special status, any kind of a special delivery, a special mechanism for Kashmiris is over. Kashmiris are as equal an Indian like you, me, anybody else across India, and that is also proven completely by this judgment today. I think it's a big victory for the Modi government. I'm not sure many of them were really expecting such a clarity in the judgment, but I think the judgment really vindicates the stand of the Modi government that 370 had to go to bring in integration, to bring in equality in J&K, and as you also threadbare laid out, the central provisions that had to be admitted in J&K were missing. There was a lot of discrimination. There was inequality in existence, not just with women, with the Valmiki community and the local Kashmiris also. And that has been given. And one point that we are also missing out is that it has upheld the union territory status to Ladakh. That was a long wish for the people, and it has not completely commented on the statehood to the J&K, but directed that because Solicitor General has promised that statehood would be given as per a commitment to the Parliament, then we direct them that it should happen at the earliest. But the election should happen by September 30th. In my understanding, that is also not completely to be adopted because there are security concerns. That's how the Chief Justice began, that we admit that there are security concerns. If the security is permitting, I hope the elections would happen.
Okay, I'm also joined by Lalit Ambardar. He has been, been part of our group listening into what the Chief Justice of India was saying when he was reading out his part of the verdict. Your opening comments, sir.
I think I never had any doubt that Supreme Court of India, because after all, Supreme Court is of India, would come in the way of constitutional integration of complete constitutional integration of one part of India with the rest of India. I think today's 5th of August 2019 was an historical day. Today's upholding that decision by the Supreme Court of India by such profound explanation of each and every aspect and argument that was raised against 5th August 2019, I think is no less historical in significance. And thirdly, this also paves way for further reorganization of Jammu and Kashmir state. If today is a union territory, it will become a state, and then also reorganization, because as you I must point out, the Kashmiri Hindus have been demanding return and rehabilitation via union territory of Jammu and Kashmir. I think this paves way for further reorganization. I think that should also happen. And also, we're looking forward to the same Supreme Court of India to look into the genocide of Kashmiri Hindus, which came about through Kashmir Jihad, which was a consequence of Article 370, because in 47 we said we don't agree with Jinnah's two-nation theory, and yet we accorded Article 370 to Jammu and Kashmir and allowed a mini Pakistan to flourish in Kashmir. As a consequence, we have suffered, and Kashmir Jihad continues to bleed India. And I think this is historical, and credit should go to the Narendra Modi's government that showed political spine and removed this obnoxious piece, or rather regressive piece of constitutional arrangement that allowed Islamofascistic ecosystem to flourish in Kashmir. And worst victims were Kashmiri Hindus. I think
I just want to add one line to what
you like. Mr. Ambardar, just wait a minute. Ashok.
See, what really has happened today is that till now, for 75 years, Jammu and Kashmir was given a special status under the Constitution of India. But today, after this verdict, what the Supreme Court has done is that Supreme Court has ensured that Jammu and Kashmir as a territory comes on par with every other state in this country. And the special treatment which was given to it has been withdrawn by the central government. They have given the green signal or thumbs up to the government decision and said that the government of India was empowered to do this. And for that, they gave their reasons that number one, the whole argument that 370 is a permanent provision under the Constitution of India is wrong. 370 is a temporary provision to meet special circumstances that were there in the state of Jammu and Kashmir. Secondly, they have also said that as far as Jammu and Kashmir is concerned, it was bifurcated and by the government order into 2 union territories. Now they are saying that the government of India has made a statement, it will revert to statehood, but as far as Ladakh is concerned, Ladakh will continue with the union territory status as the central government is empowered to create a union territory.
Okay, the bench has risen. So the bench has risen. Basically, it's. I think they have read out the verdict. The bench has risen. Please complete the point.
So the point here is that the Supreme Court has cleared the air of uncertainty that has surrounded not just Jammu and Kashmir but also Article 370. It has for all the times to come made it amply clear that 370 was a temporary provision. The government of India had the power to abrogate or revoke it anytime. 370 existed only to meet the special needs and special circumstances that existed in the state. Today, the government of India said that, look, we are doing this, or even the Supreme Court said that the action of the government of India was more of integrative in nature rather than desegregating it.
Okay, let me play out the bite of the Bar Association, the spokesperson of the Bar Association, the Supreme Court. Then we'll play out the chunks of the important chunks of the Chief Justice of India's verdict. There are a lot of reactions that are coming up. We'll get them. We'll get these reactions for you from Srinagar, from Delhi, all over India, and I'm sure that this is going to have a special mention, at least if not inside the Parliament, but at least outside the Parliament when MPs are coming out. Let's play the bite.
इस जजमेंट का वेलकम करता हूं क्योंकि ये जजमेंट भारत की सर्वोच्च न्यायालय द्वारा भारत के सीनियर मोस्ट 5 जजेज द्वारा दिया गया जजमेंट है और 16 दिन दोनों पार्टीज़ को जो है पूरी उनको अपॉर्चुनिटी दी गई अपने अपनी आर्गुमेंट को बताने की और उसको सुनने के बाद आज ये जो है डिसीजन आया है। वहाँ की जनता को जो गुमराह किया जा रहा था कि हमारा ये जजमेंट जो है 370 उठ जाएगा और फिर से जो भारत के खिलाफ आवाज़ उठाने वालों को आवाज़ उठाने का मौका मिलेगा, आज उनको ये मैसेज भारत की जो है हमारी सुप्रीम कोर्ट ने ये दे दिया है कि अब 370 हिंदुस्तान के कॉन्स्टिट्यूशन का कभी हिस्सा नहीं रहेगी, दुनिया भूल जाएगी कि कभी ये हिस्सा था।
Okay. Okay. Before I play out a chunk of the Chief Justice of India, you have a point to make?
Well, there were differing judgments, but there was a consensus. But you have to understand that Justice Kaul, one of the judges from the Supreme Court who's about to retire, is also from Kashmir. His grandfather was a diwan in the Raja's court there. And he has made a sentimental paragraph also, which I can read now. He says that the insurgencies led to migration of a part of the population. An army had to be called and nation faced the dangers. People of the state have paid a heavy price for this. There's an intergenerational trauma. The state needs healing. I cannot help but feel anguished by what people there have experienced. Even India's partition did not impair J&K's communal harmony. What's lacking is collective telling of the truth. Justice Kaul recommends setting impartial Truth and Reconciliation Commission since 1980s and suggests measures for reconsideration. So this is an important part that has also come out in this. For a very long time, the Kashmiri Pandits and the Kashmiri Hindus have been saying that justice has not been delivered ever since 89-90. There was, in fact, a lot of terrorism that began but the cases were not investigated. Not a single conviction has happened in those cases. So perhaps there could be some direction. Perhaps a government could take a cue, because some of the cases have been opened after 35 years. So whether a Truth and Reconciliation Commission to deliver justice will happen. But overall, Kartikeya, a historic judgment really, with a unanimity that is perhaps unparalleled in India's history. In this particular case, the constitutional bench giving a resounding vindication to Modi government's measures that have been taken on 5th August 2019. I think just like Lalit and others have mentioned, that if 5th August was a historic day, today is as much historic, because legal sanctity and legal sanction is being given to the nullification of Article 370, which was significant and important, because most of the separatists and most of the J&K political parties were indicating that they are hopeful that there would be a reversal of the order. I think there would be a rather larger understanding with depth that that is not going to happen now. 370 is the past. You have to look towards the future, and in future you need to uplift the lives of the common people. The kind of trauma that they've gone through, local Kashmiris, they've only seen guns, either of the army or of the terrorists. So that needs to end. There needs to be a chance being given to peace, development, and that will only happen when there is democracy in the real sense that applies there, elections, statehood, but also end of separatism, end of this Hawala racketeering, end of drugs, end of corruption, end of this mindset of jihad in Jammu and Kashmir.
Okay. Let me play out a very important chunk of the Supreme Court of India's Chief Justice, which is an operational part of his verdict. Then I'll go to my guests and my colleagues in the studio. But let's play out that 4-minute chunk first.
We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination, as understood by the definition of sovereignty, exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Kaul was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the Dominion of India did not arise in that case. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President in exercise of the power under Clause 3 of Article 370 is a culmination of the process of integration. Thus, we do not find that the President's exercise of power under Clause 3 of Article 370 was mala fide. Having concluded that the power under Article 370, Clause 3 subsisted even after the dissolution of the Constituent Assembly, we have held that the exercise of power by the President to issue CO 273 is a valid exercise of constitutional power. All provisions of the Constitution can be applied to Jammu and Kashmir through the exercise of power under Article 370(1)(d). The power under Article 370(1)(d) can be used to apply one provision, more than one provision, an entire part of the Constitution, or all the provisions of the Constitution, that is the entire Constitution. The provision does not make a distinction between one or all provisions of the Constitution. Non-application of mind cannot be claimed merely because CO 272 applies all provisions of the Constitution to Jammu and Kashmir in one go. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The previous constitutional orders, which modified Article 370 through Article 367, were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3 by taking recourse to Article 367. The validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary.
मेरी पहली प्रतिक्रिया तो ये है कि सुप्रीम कोर्ट ने बहुत बारीकी से हर एक विषय को देखा है। जो मैंने सुना चीफ जस्टिस जो पढ़ रहे थे उसमें एक एक क्लॉज एक एक सब क्लॉज को उन्होंने देखा है और सब परिस्थितियां देखते हुए उन्होंने एक नतीजे पर पहुंचे हैं। मैं उसका स्वागत करता हूं क्योंकि बहुत दिनों से ये बात हवा में थी, तो अब कम से कम स्पष्ट हो गया है कि जो हुआ वो वैध था। राजनीतिक रूप से चाहे कोई समझे कि नहीं होना चाहिए था वो बात और है, लेकिन लीगल दृष्टिकोण से, न्यायिक दृष्टिकोण से वो वैध है। एक तो बात ही हो गई। दूसरी दो बातें बड़ी अच्छी सुप्रीम कोर्ट ने कही। मैं तो चंद्रचूड़ जी को, सुप्रीम कोर्ट को बधाई देता हूँ। एक तो उन्होंने कहा कि जल्द से जल्द हमारी स्टेटहुड फिर से मिलनी चाहिए। मैं आरंभ से कह रहा था कि जो जम्मू कश्मीर को काट के दो हिस्से में करके और इसको यूनियन टेरिटरी बना दिया, वो हमें स्वीकार नहीं था, किसी को भी, किसी के गले से नहीं उतर रही थी। क्योंकि जम्मू कश्मीर एक बहुत विशेष राज्य था। पहले कहते थे ये मुकुट है, ये भारतवर्ष का ये है, और मुकुट क्या रहा, फिर हरियाणा और हिमाचल से भी नीचे आ गए, यूनियन टेरिटरी बन गए। तो वो जल्द से जल्द, मैं समझता हूँ, मेरी मोदी जी से भी यही प्रार्थना होगी कि अब वो जल्द से जल्द राज्य का दर्जा दे दें। ये ज़रूरी नहीं कि पहले चुनाव हों फिर उसके बाद राज्य का दर्जा दिया जाए, बल्कि अगर चुनाव हों तो राज्य के लिए हों, यूनियन टेरिटरी के लिए क्यों हों।
एक होता है कि
the politics of it, the legality has been taken care of, but I think the political part is it's another chip for Bharatiya Janata Party. I mean, so because it was being questioned legally, that was a political area which was open to those who were opposed to this. Now with this seal, can we say that they have achieved two principal objectives of their post 1980 avatar, which is Uniform Civil Code of Law, Ram Mandir, and abrogation of Article 370. Two are done. Politically, how do you see that, Brijesh?
Well, you know, I'm not getting into what the pamphlet said. What I know for sure, or what I can gauge from, as I have been following the party for such a long time, I think this is going to be one of the biggest issue as far as 2024 is concerned.
Okay.
The reason why I say this is that, Ram Temple was a slightly different issue that was tackled. Now you have a Bhavya Ram Temple, which was to be inaugurated by January 22nd. Jammu and Kashmir has been a very integral or intrinsic part of debates between nationalists and the liberals, as it has been put. Where the nationalists would say, or the BJP, RSS, Jansangh and others would say that, that the government, the subsequent government right from 1951 onwards till this date, they have been very, very lenient. They purposefully allowed the situation to fester. They allowed this situation to come to a level where, the entire statehood come under threat, the country came under threat, and they allowed to, let the situation slip. Modi government came, and in the first month of its this thing, they not only smashed it, but look at how it has been ratified by the 5 judges constitution bench. Because the bench, in a way, when I was listening to Justice Chandrachud in fact was doing, was saying something which point by point will be raised by all the Congress BJP spokesperson to press home the point that, see, he's a Chief Justice. And if I may say so, with no pun intended, that, Justice Chandrachud has been lapped up by saying that, that he's one of the most liberal judges you can see. So with his antecedents all in order, if that Chief Justice is saying this kind of line, do you understand how wrong the Congress has been? I mean, this is the line I think the BJP is going to follow through.
Okay, I'm also joined by Dr. Rajiv Nanda. So how do you look at this judgment, its ramification, its repercussion in the legal context, sir?
Well, it's a historic day. First historic day was in 2019 when the Article 370 was abolished from the Constitution of India, taken off from the books. Today, now, Constitution bench consisting of 5 judges has given a unanimous judgment, though there are 3 different judgments, but they are all concurring with each other. One is by the Chief Justice of India, other is by Justice Khanna, Justice Gawai, and third is by Justice Kaul, who himself hails from the state of Jammu Kashmir. His father was rather a diwan in the erstwhile state. What has been held today is, I'll be very brief in sharing my view, that yes, the Parliament of India had the power to abrogate 370. The absence of Constituent Assembly in the Jammu and Kashmir was not, as the argument raised by the petitioner, is of no consequence. And with the signing of instrument of accession, it was a complete merger. There is no question of Parliament of India not having the power to abrogate Article 370. One very good thing which there are various reasons given by the Chief Justice, summarized all those. It is a detailed thing to be read. But one very good thing which has happened is that the Supreme Court has directed that the elections to be held to the state by September 2024, which means the restoration of the democratic rights of the state. Now, this will depend because the Modi government had said at that point of time that this transformation of the state into the union territory is only a temporary phase. As and when the normalcy will restore, perhaps the statehood will be also restored. So today, the decision will be after, I think, to my understanding, after March, when the Lok Sabha elections are over, the call will be taken whether the elections are to be for the state assembly or to the union territory.
There's a little bit of a problem in your audio, Dr. Nanda. Let me play out the bite of Ghulam Nabi Azad.
जो यूनानिमस जजमेंट थी, ये सर बहुत निराशा हुई, बहुत अफसोस हुआ। मैं शुरू से ही कह रहा था कि दो अदारे हैं जो इसका फैसला कर सकता है, एक पार्लियामेंट, मरकजी सरकार, और दूसरा सुप्रीम कोर्ट। जाहिर है मरकजी सरकार करती नहीं, उन्होंने तो आर्टिकल 370 को ख़त्म किया, कानून बनाकर नया। अब ये आखिरी हमारी उम्मीद थी कि सुप्रीम कोर्ट इसमें सुनाई करे और इसका फैसला सुनाए। 3 महीने 4 महीने इस पर बहस हुई पार्लियामेंट के अंदर, और मुख्तलिफ वकला ने अलग अलग पार्टीज़ को और रियासत जम्मू कश्मीर के लोगों को रिप्रेजेंट किया, और उसके बाद जो आज यूनानिमस फैसला आया, उससे मेरे ख्याल में जम्मू कश्मीर के सभी लोग, चाहे वो कश्मीर के हों या जम्मू सूबा के, वो खुश नहीं है। मैं आज भी समझता हूँ कि ये हमारे रीजन के लिए एक हिस्टोरिकल चीज़ थी। हमारे जज्बात जम्मू कश्मीर के लोगों से इससे जुड़े थे, चाहे वो 370 हो या 35A हो, जिस 35A को महाराजा हरि सिंह ने 1925, 1927 और 1928 में बनाया था कि बाहर वाला न नौकरी कर सकता, न बाहर वाला ज़मीन खरीद सकता। और जब हमारा आईन बना तो 35A की शक्ल में उस महाराजे को फैसले को आगे बढ़ाया था। तो आज वो भी ख़त्म हो गया, दोनों चीज़ें ख़त्म। इससे हमारी स्टेट की इकानमी को बहुत नुकसान होगा, ज़मीनें महंगी हो जाएंगी, पूरे हिंदुस्तान के लोग जम्मू और श्रीनगर आएंगे। हमारी महदूद, हमारी यहाँ कोई बड़ी इंडस्ट्रियाँ नहीं है कि जिसमें हज़ारों या लाखों लोग काम करें। हमारी सबसे बड़ी इंडस्ट्री है टूरिज़म, और वो लिमिटेड लोगों के लिए है। हमारी सबसे बड़ी इंडस्ट्री जम्मू कश्मीर की है नौकरी, सरकारी नौकरी, और उसमें भी अब और बहुत कम नौकरियां होती। ज़ाहिर स्टेट बहुत छोटी है, अब उसमें पूरे मुल्क के 130 करोड़ जो आबादी हमारे में वो अप्लाई कर सकते हैं हर महकमे के लिए। तो हमारे जो नौजवान बच्चे हैं या बच्चियां हैं पढ़ी लिखी, वो और बेकारी हमारी बढ़ेगी, कई गुना और ज़्यादा बढ़े। तो ये तमाम चीज़ें जब रखी गई थी आर्टिकल 370 में, 35A में, 35A में, इन तमाम चीज़ों को नज़र में रखा गया था कि एक बॉर्डर स्टेट है, एक तरफ से चाइना है, दूसरी तरफ से पाकिस्तान है, और कोई यहाँ ज़रिया आमदनी नहीं है, कोई खदानें नहीं है, बड़े कोयले की खदानें या दूसरी खदानें। तो ये चीज़ें आर्टिकल 370, 35A रखना चाहिए। मैं ये तो नहीं कह सकता कोर्ट से भरोसा उठ गया, लेकिन ये था कि एक उम्मीद थी, क्योंकि कई चीज़ों में हम सब ने, हिंदुस्तान के हिंदू मुसलमान ने पिछले कई सालों से कहा था जो कोर्ट करेगा वो आखिरी फैसला होगा। जैसे बाबरी मस्जिद के बारे में कहा था, इसी तरह से और कई चीज़ों में कहा था, और उसको स्वीकार किया था। तो अब हमारी उम्मीद थी कि सुप्रीम कोर्ट, क्योंकि वो किसी दल की, किसी पक्ष की, किसी सियासी पार्टी से ताल्लुक़ नहीं रखते हैं, और ख़ास तौर से आज की जो ये बेंच था वो बिल्कुल मैं कह सकता हूँ कि बहुत ही अच्छा बेंच था।
Okay, so now when we started our discussion in morning, you spoke about the fact that federalism is part of the basic structure of the constitution. Now we have a judgment on 370. The petitioner's argument was completely different. What ramification will it have in context of the basic structure now?
Well, listen, there are two things. One is the concept of federalism, and the other is the concept of integration. Now, India is a union of states. That is Article 1. Okay. When you say India is a union of states, it means that there is an integration of all the federating units. Here, what we had was a situation is that Jammu and Kashmir was given a special status. Now, that special status was given as a temporary measure because of certain conditions that were prevailing in the state. There was a war when the instrument of accession of Jammu and Kashmir was signed with India. Thereafter, the state has been rocked by militancy and separatist tendencies, so that special status continued. Now, in 2019, the Government of India took a conscious decision that these conditions must be done away with. There has to be a total integration of Jammu and Kashmir in India. Now, this process of integration has to be balanced with the idea of federalism. Now, under the Indian Constitution, the constituent units, which are the states, have separate power, the power to legislate on subjects which are under the state list and the concurrent list. A similar provision exists for all other states in this country. But Jammu and Kashmir, there was a special provision which said that the state assembly enjoyed special powers. Now, this judgment says, it strikes a balance between the idea of federalism. You cannot have a federalism. The Supreme Court said that when Jammu and Kashmir signed the treaty of accession or the instrument of accession, there was no sovereignty in it. This idea of sovereignty has persisted for the last 75 years. The political leaders of the state have constantly hammered on the fact that there vests in the state a degree of sovereignty.
Okay.
We are not completely aligned.
So, are you saying that it was a political construct? Are you saying that it was a political construct, not vested legally?
The idea of sovereignty was a political construct. But
Correct.
Here, the Supreme Court of India is saying that, look, this idea of sovereignty cannot be political, because it has to be seen, a broader picture has to be seen. You have to look at the Constitution of India. Constitution of India is supreme. You cannot have anything above it, and it has to be integrated.
Okay, okay. Let me play out couple of bites of the CGI.
We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination as understood by the definition of sovereignty exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Kaul was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retained sovereignty upon integration with the dominion of India did not arise in that case. We have held that the state of Jammu and Kashmir...
So now, that's the legal part, but there is also a celebratory part. People are out in the streets, they are celebrating it. There is a component which feels that this is the best thing to have happened. Now these are the visuals that are coming in from Jammu. Let's play up the nat.
आप देखेंगे पीछे लगा भारत माता की भारत माता की भारत माता की डिसीजन को लेकर यहाँ पर वो यहाँ पर बहुत खुशी है जिस फैसले का इंतजार था भारत माता की हम कई दिनों से इंतजार कर रहे थे भारत माता की भारत माता की भारत माता की आप देखेंगे पीछे लगा
tongs against what is a political construct which you are talking with Ashok. The fact is that they will say that the reason why this was not done is because of a massive mismanagement by the Congress party. That is what is going to be the political construct of the BJP. And you know, this particular situation is something which resonates with people all across North India, all across from Kashmir to Kanyakumari. This will have one resonation or other. And I think, you know, this has become one of a key political issue which has worked brilliantly in favor of the Bharatiya Janata Party. There were several naysayers. There were talk about how the government has done something which cannot have been done legally, constitutionally, and people, they were waiting for this day when the Supreme Court will lay bare exactly what happened, whether the government of India took a wrong decision, whether the government of India was in the capacity to take a decision or not. Article 370, which was, if I may use the Hindi word, which was a hawa in the entire political discourse, all that has been cut short today. Article 370 is a temporary proviso. This is something which the BJP is going to go to town with, saying that how Congress allowed a subterfuge to be built across the political spectrum of the country, length and breadth of the country, that Article 370 is inviolable. Our government came, we destroyed it. That is what the BJP is now going to press home the point, and that is what is going to work brilliantly for them. Because, you know, I've seen how people reacted when this was struck down, when Home Minister Amit Shah rose to announce abrogation of Article 370. Now today is the validation time. And elections are literally 2 to 3 months round the corner before the dates are announced. I think this will play big as far as 2024 is concerned.
Ashok. Brajesh rightly pointed out that how Bharatiya Janata Party is going to take this issue, go to the town, hammer it down the throats of the people and say, look, this is what we have done. Another thing is that this particular judgment does a great deal of wonders for the personal image of Prime Minister Narendra Modi. Now, Prime Minister Narendra Modi's image will be projected as a Prime Minister who is not fighting shy of taking bold decisions for the integration of the country. Now, Bharatiya Janata Party has for a long time been saying that Article 370 is something which has a disruptive tendency, or it harbors the disruptive tendencies amongst the people of Jammu and Kashmir, as was rightly pointed out during the discussions in the Supreme Court, where the solicitor said that there was a psychological duality which exists in the mind of the people of Jammu and Kashmir. So that psychological duality has been destroyed, has been completely done away with. And here we'll have Prime Minister Narendra Modi going into the general elections in just a couple of months' time, riding on this wave of Article 370.
And they will also add this as a particular, as deception by the Congress party, because the BJP said that this is something, the duality, where one sign, one insignia, one flag, which they have been saying it for such a long time, was a myth, was a deception which was perpetuated by the Congress party. And look, when we came to power, we abolished it. It took a lot of political courage on part of Prime Minister Narendra Modi, and people, naysayers, they will term Kapil Sibal's previous association with the Congress party, saying that they went to the court, a constitution bench has ratified every single move taken by us. So this was perfectly doable. Now the Congress should come forward and explain why it has not been done so far.
Okay, now let's play out a couple of vox pops that have come.
वहाँ पे कोई इलेक्टेड गवर्नमेंट नहीं है, और फिर यह है कि राष्ट्रपति का जो यही पे पहले भी इसी सुप्रीम कोर्ट में, भारत के सुप्रीम कोर्ट ने ही 370 और 35A को जो है वैलिड करार दिया है, क्योंकि 2 बार पहले भी जो है इसी अदालत में सुप्रीम कोर्ट की वैलिडिटी को लेकर मुकदमा लड़ा जा चुका है। लेकिन अब क्योंकि हालात बदले हैं, सरकार बदली है, तो लिहाजा अब जो है सुप्रीम कोर्ट का वर्जन जो है, सुप्रीम कोर्ट का बिहेवियर भी हम समझते हैं उसके साथ चेंज हो चुका है। बहुत ज़्यादा मायूसी है जम्मू कश्मीर के लोगों ने जिन शराइत पे, जिन कंडीशंस के साथ भारत के साथ विलय किया था, वो 3 शराइत थी, आपको पता, फॉरेन अफेयर्स और कम्युनिकेशन और डिफेंस का जो था। और आज जो है जम्मू कश्मीर के लोग ये समझते हैं कि उनके साथ विश्वासघात हुआ है, और कॉन्स्टिट्यूशनल जो गारंटी उनको दी गई थी, ठीक है जी, और 370 और 35A के जो एक पुल था इंडिया और कश्मीर के बीच में, तो वो समझते हैं कि उसका विश्वासघात हुआ, उनके ट्रस्ट को जो है वो ब्रेक किया गया है।
आर्टिकल 370 रिवोक के बाद यहाँ पे जो है बहुत सी डेवलपमेंट हुई। आपको तो पता ही है कि आर्टिकल 370 से पहले तो यहाँ पे तो टूरिज्म का उतना फ्लो था नहीं, तो आर्टिकल 370 रिवोक होने के बाद यहाँ पे तो टूरिज्म में भी बहुत बूस्ट हुआ, तो बहुत से टूरिस्ट भी यहाँ पे आए, डेवलपमेंट भी बहुत हुई, और जो बेरोजगारी है वो भी खत्म हुई। सुप्रीम कोर्ट ने जो फैसला लिया हम बहुत खुश हैं उससे, क्योंकि आर्टिकल 370 रिवोक होने के बाद यहाँ पे तो है बहुत सी डेवलपमेंट हुई, स्टोन पेल्टिंग बंद हुई, यहाँ पे जो आज आम इंसान भी है वो भी आराम से बैठकर अपना वो जो है कारोबार करता है। तो इसलिए हम बहुत खुश हैं कि आर्टिकल 370 रिवोक हुआ, हम बहुत खुश हैं कि इससे जो है यहाँ पे जो है कश्मीर में बहुत सारी डेवलपमेंट हुई।
Today's Supreme Court judgment on Jammu Kashmir Article 370 is a historic judgment. Today the Honorable Supreme Court has cleared all the confusion, and it has clearly said that Jammu and Kashmir is integral part of India. The Honorable Supreme Court has also said that the Parliament is supreme, and all the provisions of the Constitution of India are applicable in the context of Jammu and Kashmir. So therefore, the Jammu and Kashmir is now integral part, and it is the Constitution bench which has accepted this position under the Constitution. The second thing, that the State Reorganization Act 2019 has also been upheld. Now, the only caveat the Honorable Supreme Court has said that the Jammu and Kashmir has to be restored its statehood, and the election, in terms of the statement of the Solicitor General, they have said that election must be held by 30th September 2024, and Jammu and Kashmir must be restored statehood. Whereas
they have also upheld that Ladakh will remain union territory and there is no illegality, no invalidity so far Ladakh is union territory of the country. The third aspect is that they have said.
And I'm being joined by General Sivaj. I am also being joined by Dr. Kapil Sankla. Dr. Kapil Sankla, how do you look at this verdict? Clears a lot of things, settles an issue. This is historical in nature.
I think I would say that this is legal, the law in the right perspective, in the right direction. And as a lawyer, dehorse the politics, I will tell you this. And there's a reason behind it. As far as the exact law and the constitution is concerned, the Honorable Court stated that 370 Part 3 still survives, dehorse the legislature having made defunct. And the law itself, the Honorable Supreme Court number of judgments said that what cannot be done directly cannot be done indirectly. And so therefore, and also that where there's a legal vacuum, the courts will step in. So when you look at these two, the basis of law, the basis of criminal, the basis of legal jurisprudence, you will see that just because, an A is done and you remove the legislature, you cannot subsequently say now nothing cannot be done because there's a vacuum and that vacuum will be filled up. And the vacuum will be filled up either by the legislature, failing which by the court itself. So that is first part of it. And the second part of it is, as a lawyer, I have practiced there in some matters and I saw that the laws were very regressive. They were not following the development of law that has happened because of the Honorable Supreme Court and because of the legislature amendments protecting women, women's rights, protecting RTI, that is citizen rights, etc. None of that was there in Jammu and Kashmir. So the law had to catch up and the law has caught up. So therefore, if you say that, oh, we don't want to be a part of India because we have some special status, either you show that the special status is benefiting the people of Jammu and Kashmir, which it wasn't. Or you say that the special status is under a power which cannot be taken away. It can be. 373 was a part of it. And lastly, either you show that dehorse that the law itself is developing, which it wasn't. So under the circumstances, as far as a lawyer is concerned, as I said, it is a legal path in the right direction. And secondly, I would also say this, that if you disconnect the politics of it, what do you have? You have a state where the court says that will be given back its statehood, not just union territory, which will be open to judicial, scrutiny. And also that as far as the laws are concerned, they have to catch up with the laws all over India. And also the binding effect of the judgments of the Honorable Supreme Court and the amendments of the Judicial. So all of that has been upheld today. So when you disconnect politics, it is in the right direction for the people of Jammu and Kashmir. And I'm very glad that the Honorable Supreme Court also stated that in the rights of the people, elections are going to take place. So any argument disconnected to that, to politicize the issue also goes away. So this is my answer to you.
About Truth and Reconciliation Commission. He also spoke about Truth and Reconciliation Commission.
Yes. So as far as that is concerned, please do understand another very important aspect. That the laws as created, especially the constitution that is created, is to integrate India and the citizens of India, right? So if you actually come up with an interpretation that is regressive in nature, that actually breaks or creates a divide or a disconnect, or creates an element that an X, which is a part of India, is separate, that itself has to be read in the correct light of the purpose of the constitution. And the purpose of the constitution is to integrate. So what has been, and I think Justice Chandrachud, the Chief Justice, also very rightly said that the purpose was to integrate and not to disintegrate. And to that effect, the judgment again is in the right direction. Also, please understand this, that if we again take away the Constitution of India and we bring in just the laws, CRPC was regressive. There was too much power with the police and too little protection to citizens of India. The laws were absolutely against the women because it did not give them the co-pastory rights, the right that you have as soon as you're born in the property of the grandfather, the right that you have just merely because you're born in the family was not there to the women of Jammu and Kashmir. And various other laws that were protective in the nature to the people and the citizens were not being followed, were not being brought in, were not being amended. amended. So all of that today with this is also going to be an integral part of it, which, as I said, is a direction, a right direction.
Dr. Kapil, you stay with me. I'm also joined by General Sivach. General Sivach, it also settles certain security issues, you know, which came with 370. It settled them for eternity. Don't they, sir?
Absolutely. Absolutely. See, the point is today is a milestone judgment from all angles. There is no doubt about it. After Article 370 and 35 was abrogated, there was a complete change in Jammu and Kashmir as far as the security status is concerned. I can only say that, Panchayat election, district development council election were held. Stone throwing became a question of a past because whatever Hawala money which was coming from ISI to Hurriyat was choked and there was no question of any stone throwing. Then the law and order situation improved tremendously. In fact, there are only 40 to 50 registered terrorists are left. All the terrorist leaders like Jaish-e-Mohammed, Lashkar-e-Toba, and Hizbul Mujahideen was eliminated. Your counter-infiltration grade was very robust. And the whole, Jammu and Kashmir was acting like a unison. And there was a complete change. The fact was that it feeling that it is part and parcel of India. That has changed the whole status of Jammu and Kashmir. And I am so extremely happy today. The Supreme Court has now declared it totally valid, and rightly so. The privilege and the rules and regulations which are enjoyed by all the citizens of the country will be also enjoyed by Jammu and Kashmir. There was, time and again trying to convey they have a special status. The special status was on the negative side. There were people who were denied certain rights, privileges which are prevalent to other citizens of the nation. Now, after Article 370 and 35A has been abrogated, they are as equal and as good as anyone else. And therefore, the RTI, the women empowerment, the people who have gone there and declared, non-citizen of that place can get it. And that's why, see the progress which has happened in last about 2 years. Today, the tourism at the record time, there is horticulture industry coming, tourism industry coming. Countries like Saudi Arabia and UAE are ready to invest.
Absolutely, General Sivach. Absolutely.
Therefore,
absolutely, sir. I would also like to read an important tweet of Prime Minister Modi, which is part of our coverage. People should know in this coverage. The Prime Minister in his tweet has said, "Today's Supreme Court verdict on abrogation of Article 370 is historic and constitutionally upholds the decision taken by the Parliament of India on 5th August 2019. It is a resounding declaration of hope, progress, unity for our sisters and brothers in Jammu, Kashmir and Ladakh. The court in its profound wisdom has fortified the very essence of unity that we as Indians hold dear and cherish above all else. I want to assure the resilient people of Jammu and Kashmir and Ladakh that our commitment to fulfilling your dreams remain unwavering. We are determined to ensure that the fruits of progress not only reach you, but also extends their benefit to the most vulnerable and marginalized section of our society who suffered due to Article 370. The verdict today is not just a legal judgment, it is a beacon of hope, a promise of a brighter future and a testament to our collective resolve to build a stronger and more united India. Naya Jammu and Kashmir. General Sivach, Naya Jammu and Kashmir.
Absolutely, absolutely. There's no doubt. You see, this send a very positive message to the people of Jammu and Kashmir, which are totally integral part of India. After Article 370 and 35 was abrogated, it was as good as any other state of the country, and they were enjoying all privileges. I said that the restrictions, the rules, and may have been put, but the privileges which were there were enjoyed by them, which is enjoyed by every person and every person of our country. Now, the question which comes is that what change has it made in last 2 years, wherein the court has seen it, the fruits which have been enjoyed now by the people of Jammu and Kashmir were not there earlier. The question is that today there is a law and order situation is so good, there is a peace prevailing. The insurgency, militancy which was in last 20 years has been the hallmark, has now totally gone. People are so very happy. Tourism at the record time, district development council, panchayat elections have taken place. I have served there for almost 35 years. The changes which I've seen in last 2 years are astonishing. The people are so happy. People are feeling that they are part and parcel of the country. There is no ambiguity left today. And this is not ambiguity in Jammu and Kashmir. It is now no ambiguity left in the rest of the part of the country also. That all states are part and parcel of the nation, and the state government has to follow whatever is to be told by the central government. I will only say I feel so proud today that the Supreme Court has withheld withheld certain restriction or improvisation which certain people were trying to put it. Now they have said that Article 370 and 35A, which was abrogated by the central government, can valid.
General Sebat, my colleague Ashok has a point. Ashok.
Okay, Karthikeya, one thing that I wanted to just add in here is the fact that this judgment was, while it was very closely followed and very closely watched by not just the people in this country, Jammu and Kashmir, but also the fact that neighboring countries have been keeping a very close watch.
Yes.
And we have to understand that
Pakistan and China, because their policies are affected by it.
We have to reflect on that question also.
Absolutely, please go ahead.
That the fact that the Chinese and the Pakistanis will also be following very closely, because the source of funding of this separatism has primarily come from across the border.
Wonderful. General Sebat, you wanted to come in 1 minute. General Sebat.
Yeah, very good. You see, the point is very valid point which has been raised, and no doubt about it. Not only that, the roadmap for taking POJK and Gilgit-Baltistan has been totally laid now. Now, it is made clear in this verdict that Article 370 and 35A has abrogated. Jammu and Kashmir is a part and parcel of Indian state, and so is the POJK and Gilgit-Baltistan, which are illegally occupied by Pakistan, and therefore they must come back. I suppose that the roadmap to take it in future is now laid very clear. So therefore, the Pakistani and Chinese, both what excision has been taken by Pakistan will by the China will also feel the heat. I suppose this judgment which is been given, it fulfills so many aspirations of independent India and send a very good message all across, and very rightly put across. I think the Jammu and Kashmir people have left no doubt in their mind. And not only that, you see, I keep on monitoring what is happening.
General Sebat, if you ask me, General Sebat, if you ask me, what's and Dr. Kapil, I would like to join. When this is the issue of lot of unresolved issues of the Constituent Assembly, which were kept as temporary or were part of the directive principle. At least, Dr. Kapil, one temporary issue has been resolved. There is no national consensus on the issue of reservation. It's politically impossible. Everything which has been part of the directive principle cannot be pulled out, because there will be no consensus on that. But at least one temporary issue of the Constitution has been dealt by both legislature and judiciary.
Let me take it like this. That Article 370 was a thorn in the legal system of India. Because as rightly pointed out by each and every panelist, the law in Jammu and Kashmir and the people in Jammu and Kashmir suffering, the only people who were enjoying the benefits of politics and politicians. At this moment, there has been a correct interpretation in terms of plethora of judgments of the Honorable Supreme Court that a temporary structure cannot be made permanent forever. At changing time, something that was created for a warlike situation being temporary in nature, the times have changed. As far as the issue of reservations, etc. is concerned, that also will be met in due course and would be met in the course in the light of what was required and whether India as a state, as a society has gone beyond the issue of caste, color, creed, etc. So coming back to the issue of Jammu and Kashmir, we will all agree that as far as for the people of the citizens of Jammu and Kashmir is concerned, it is a direction. It is an order in the right direction. For 4 years, they have the abrogation has worked in their favor. Much development has taken place, and much has still to be done.
And I think end of this end of this coverage, I would like to say that abrogation of Article 370 will not only give a strong messaging in context of unresolved pending constitutional issues, but I think, as you very rightly pointed out, it's a signal to the global community which had an excessive say on our internal affairs because we went to United Nations in 40s, and subsequently to that China and Pakistan had a sort of a open space to internationalize our domestic issues, isn't it?
And there's one line I would also want to add, that that even if India went to United Nations, Karthikeya, it was more as a faith in the setup rather than anything else, and it was a system which let us down and not the other way around. If any country approaches United Nations, it doesn't mean that you are subverting or loosening hold over your territorial integrity of the particular state. But the fact of the matter was that yes, United Nations have witnessed in innumerable times post that is that when it comes to rich and powerful, it is a completely different dynamics, it is a completely different roll of dice, and a different one when it comes to the third world country.
Okay, so you were watching our special coverage on Article 370 verdict. The verdict is out. Article 370 is not going to be there. Truth and Reconciliation Commission, every other facets, those bare-bone details will be out. But I think it's a very important milestone in Indian history. It's an important milestone for Bharatiya Janata Party, that the party that was born in 1980s could complete two very vexed constitution, one constitutional and other legal and a faith-related issue, which is Ram Temple. And I would only say that you stay tuned. Our coverage on Article 370 will continue. Our coverage on who's going to be the Chief Minister in Madhya Pradesh and Rajasthan will continue, and a special coverage of Gaza operations will continue. Stay tuned. You are watching News9 Live.
मेरी पहली प्रतिक्रिया तो ये है कि सुप्रीम कोर्ट ने बहुत बारीकी से हर एक विषय को देखा है। जो मैंने सुना चीफ जस्टिस जो पढ़ रहे थे, उसमें एक एक क्लॉज, एक एक सब क्लॉज को उन्होंने देखा है और सब परिस्थितियां